Welcome to the General Laws and Technology Committee. If the clerk could open the roll. Okay. We have a lengthy docket today. We don't have the delegates here yet, but we do have several similar bills, 6 similar bills that we can start with. HB 133 from Delegate Converse Fowler is similar to Senator Rouse's SB 650, a local government ongoing health care for employees exposed to toxic materials. Senator Rouse, have you and Delegate Converse Fowler discussed this?
We have not, Chairman.
Because we could conform it, or we could move on. I guess.
Mr. Chair, I know our bill went to finance and we scripted out.
Yeah, this bill would go to finance if it does. It's just a question of whether we conform unless there's some reason not to. Why don't we?
Move to conform.
Why don't we conform that, and then if she comes up with any other reasons, we can revisit that. But there's a motion to conform HB 133 in a second to SB 650 from Senator Rouse. All in favor, please say aye.
Aye. Move to report and refer to finance.
Okay. And that was that was a unanimous vote, the Senate version, and we'll open the roll, please.
Ayes 10, no 0.
Okay, that bill reports. Let's skip over Delegate Thomas for a moment and move on to Delegate McClure's HB 368, which is similar to SB 195 from Senator von Valkenburg, dealing with a advisory group to evaluate the Uniform State Building Code. And these are very similar, except the Senate bill includes firefighting professionals. Yes.
We just for this, we would just need to move the amendment that was just handed to you that changes firefighter to fire official.
Fire code officials.
Fire code official.
Okay, so
moved.
There's a motion and a second to, on line 12 after group, insert including fire code officials. All in favor of that amendment, please signify by saying aye.
Aye.
Any opposed? Okay, we now have the amended bill before us.
Move to report as amended.
Second. Motion to report HB 368. Could the clerk please open the roll? Okay. Next we have from Delegate Cherry, similar to Senator Locke's SB 36, the Freedom of Information Act amending the definition of a meeting. HB 818 is a little different than Senator Locke's in that it says the appointment of more than 2 members of a public body to another public body does not constitute a meeting of the first public body, and it deletes the definition of public business. Senator Locke, have you discussed this with Delegate Cherry?
I have not, so I believe the best course of action would be to conform them.
Okay.
And then we will get together on it.
Okay, so is there a motion to conform HB 818 to SB 36? All in favor, please signify by saying aye. Aye. Any opposed? Okay, we now have HB 818 before us that passed Senate unanimously. Okay, there's a motion and a second to report HB 818. Please signify your preference on the voting board.
Ayes 11, no 0.
Thank you. Okay, let's go on to Delegate Munton King's SB 1461, which is similar to SB 544 from Senator Bagby. This is the short-term rental property locality's ability to prohibit a lessee or a sublessee operator. Okay, the bills do have some differences. In the Senate, we included a phrase, notwithstanding any other provision of law enacted after December 31st, 2023, shall require that a special exception, special use, or conditional use permit be obtained for the use of a residential dwelling as a short-term rental, as long as it's legally occupied by the property owner as his primary residence. We can conform that, or we can wait for I guess we should conform it if we don't.
I'm not getting direction.
I don't know if we should.
Coming up. No, they're recommending not conforming.
Okay, so why don't we hold off for the delegate on that one? Okay, Delegate Tran is here. Hi, welcome. I think you've got two bills with us today.
Thank you so much, Mr. Chairman. I have two bills in front of you today. Is there one you would like to hear first?
Whichever you prefer.
All right. Can we do 1487 first?
Okay. HB 1487. Sure.
Page 1111. Page 11.
Mr. Chairman, are you ready?
Yes.
All right.
We're ready.
House Bill 1487 directs the Department of Housing and Community Development to translate model rental forms that are already developed and published into the top 5 non-English languages spoken in Virginia, and to make those translations available to the public. Over the past 5 years, DHCD has developed model tenant and landlord resources and posted them on their website. These include resources and statements of tenants' rights and responsibilities under the Virginia Residential Landlord and Tenant Act and the Virginia Manufactured Home Lot Rental Act. All of these forms are clearly available in English. Some have been translated into Spanish, but recognizing that we have such a diverse Commonwealth and over 500,000 Virginians speak a language other than English as their primary language, and we think it would be really helpful to all tenants to know what their rights and responsibilities are by translating the forms into the top 5 non-English languages spoken in Virginia. Those languages, for your information, based on the census data, are Spanish, Chinese, Vietnamese, Arabic, and Korean. And also, I'd like to just highlight, to save on costs, the bill mirrors the ability that's available to the Department of Elections under the Virginia Voting Rights Act for DHCD to have these materials translated by volunteers, as long as the translation is then validated for accuracy prior to being posted.
Thank you. Are there those here today to speak in support of HB 1487? If you could, okay. If you could approach, and we're on a express docket today.
Thank you, Mr. Chairman, members of the committee. Christy Mara with the Virginia Poverty Law Center, and we strongly support the legislation.
Thank you. Welcome.
Laura Dobbs, Housing Opportunities Made Equal, and we support the bill as well.
Okay, is there anyone here to speak against HB 1487, either here, or is there anyone waiting to speak online?
Move
Okay.
report.
Second.
Okay, there's a motion and a second to report HB 1487. Please open the roll.
Try again.
Ayes 9, no 6.
Okay, your bill reports. Now you have HB 1355.
I do, sir. Mr. Chairman, I have HB 1355, and I have amendments to this bill.
Move the
Okay,
amendment.
first we'll take up the amendments. There's a motion and a second. They basically, is that a delayed enactment date? Is there more to it?
There's one amendment that delays the enactment date further to July 1, 2026. One of the feedbacks we've heard from local governments is that as the budgets are being developed now for 2025, it makes implementation of this bill harder if it was just starting in July 1 of 2025.
Okay.
So that's the amendments is on lines 135 to 190.
Okay, so I think we have a choice here. We can, well, first let's take up the vote on the amendment. All in favor, say aye. Aye. Any opposed? Okay, so we've got a choice. We can take up the bill with the delayed effective date, or I don't know that this has had a thorough review. It could go to the DGS procurement work group for study and still have time to be taken up next session if they report back to us this year. Are there those waiting to speak to this bill? Please come forward.
Good afternoon, Mr. Chairman. Randy Pearson on behalf of the Autism Society of Central Virginia, as well as the Autism Society of Tidewater, Virginia. We strongly support the bill and thank Delegate Tran for bringing it forward.
Thank you. Okay. Do you want to, is there anyone speak against the bill? Okay. Did you have more, did you want to close out? Oh, there's someone on one line. Okay. If you could unmute yourself and identify yourself and show yourself on camera.
Page 11. The first showing Bill 18 on page 11. Okay. I wrote on that, right?
Lori Crescent, can you please unmute, turn on your camera and begin your testimony?
Page 11.
Good afternoon, Mr. Chairman and committee members. I am Lori Christine, Coordinator of Academic Accessibility at the University of Virginia. Today, I'm representing the Virginia Higher Education Accessibility Partners Board of Directors in strong support of House Bill 1355. Since the APA was signed into law in 1990 and the Code of Virginia Information Technology Access Act passed in 1999, the strategies of most entities within the Commonwealth have been to address accessibility in a reactive fashion, such as when a student with a disability enters school or a state entity is served with a complaint by the OCR or DOJ. This strategy has led to systemic discrimination by often excluding people with disabilities access to a rapidly changing digital world. Since 2006, at least 22 covered entities in the Commonwealth have signed resolution agreements for failure to ensure equivalent access to information and communications technology. As a result, many Virginians with disabilities were denied equivalent access to critical resources, and covered entities endured significant costs to achieve compliance. Being mindful that the current code has not been updated since 1999, House Bill 1355 lays the foundation for improving digital access for all Virginians. It does this in 4 areas. First, it broadens the current law to cover all persons with disabilities, as well as expands the entities covered by this act. Second, it places the responsibility and costs with the vendors to tell us how well their product aligns with Section 508 standards. Currently, this responsibility, as well as the associated legal exposure and costs, are borne by each covered entity. Third, it introduces the need for equally effective alternative access plans, which acknowledge that some features of a digital tool are not accessible, necessitating us to find ways to accommodate for this in accessibility. Finally, it ensures citizens of the Commonwealth a path to indicate when a barrier to access has been encountered, find information on how to file a grievance, and asks how each covered entity to identify a staff person who is tasked with overseeing these efforts. House Bill 1355 modernizes and brings current state code in alignment with other existing state and federal laws and standards, begins to address costs and legal exposure from a proactive stance, fosters transparency, and improves digital access for all Virginians. We strongly urge you to support the passage of this bill. Thank you for your time.
Thank you. Delegate Tran, did you have any concluding comments?
Mr. Chairman, I see that the line for folks with concerns is just growing. So I will just add, I think Lori our witness had explained and summarized the bill, but Just so you know, right, the Virginia Information Technology Access Act went into place in the late 90s when floppy disks were still popular, and the covered entities are state and local governments and institutions of higher education and focuses specifically on visual disabilities. So what this bill does is attempts to broaden the scope of this part of our code to cover all disabilities, as we know that there are different and additional disabilities that intersect with technology use, and also to add K through 12 as one of our covered entities. I think you'll hear from some of the stakeholders that I think we still have some work to do on threading the needle to get to the right place in terms of a policy around procurement of that. I'll leave them to share their concerns.
Thank you. Okay, I didn't realize there were folks lined up. Why don't we put 2 minutes on the clock? If you could, be mindful of the people behind you in your comments and come forward and identify yourself and your concerns.
Hey, good afternoon, Mr. Chair, members of the committee. Josette Bolova with the Virginia Municipal League. First, I want to thank the patrons so much for working with us to help us try and alleviate as many concerns as possible. But we still do have some concerns over the implementation and the cost associated with such. New equipment, staffing, software upgrades, everything is in the millions of dollars to implement. And it also goes against federal standards. So thank you.
Thank you.
Good afternoon, Chairman. Jennifer Vinnie, Fairfax County. We support what the person from VML stated. The federal law calls for reasonable accommodations, and this expands that to proactive access for all peoples of the public and employees from the locality, which is part of the reason. And while we are thankful for the delayed enactment and the amendment put in about costs, Fairfax County very rarely has a contract under $10,000, and so the fiscal cost is still very high for us.
Thank you.
Mr. Chairman, Ellen Davenport with the Virginia Community College System. We represent 23 community colleges, and we have a centralized IT procurement and contract administration function. We estimate that we would need an additional 10 personnel to accommodate this bill, and the estimated fiscal impact going forward would be continuous. We appreciate the extra time that Delegate Tran has put on the bill, but we'd rather have it go to a study or to the work group. Thank you.
Mr. Chairman, Joe Lurch with Virginia Association and County, and for the previous concerns raised, we cannot support this bill. Thank you.
Thank you.
Mr. Chair, members of the committee, Alana Crennan with Arlington County. We thank the patron very much for working with us, but we support sending HB 1355 to the GGS procurement work group for the reasons previously stated. Thank you.
Thank you. Okay, we've heard some concerns. This was last updated in 1999. The question is whether we were to pass with the late enactment date or to send it for study so that we can be sure that we are up to date. I believe Senator Reeves has some questions or comments.
Mr. Chairman, I just have a motion.
Okay, in the motion?
It would be gently pass it by with a letter from you to add this to the General Studies Work Group.
Okay, so there's a motion, and do I hear a second?
Mr. Chair, question. By pass by, you mean continue to 2025?
Yes. Pass by for the year with the letter to DGS Procurement Work Group is the motion. Carry over. Let's open the voting roll for that.
Ayes 15, no 0.
Thank you, Mr. Chairman.
Thank you. And Delegate Tran, if you could help me out by getting me a list of some of the stakeholders who had opposition so that we can make sure that we include them in the process, that'd be helpful.
Great, I will do that. Thank you so much.
Thank you. Okay. We have a queue of delegates now with Delegate Wiley, then McQuinn, then Williams, then Lopez, and a few more after that.
Good afternoon, Mr. Chairman, members of the committee.
Good afternoon.
House Bill 1101 is in front of you. This bill amends the Procurement Act to broaden the definition of professional services to include investment and financial advisors procured by the Department of Treasury. The reason why this is important, currently it's investment and financial advisors must be procured pursuant to the same procedures that apply to the procurement of commodity products like furniture and other equipment. Those procedures require that price be a major component of the selection process. Treasury is currently managing about $40 billion of investments and $20 billion of debt. Given these levels, it seems more prudent to select investment and financial advisors based on their qualifications rather than running the risk that a less qualified vendor will buy the business. Price will still be a factor, but not as much of a determining factor when selecting the vendor. The definition of professional services currently includes accountants, actuaries, architects, surveyors, lawyers, dentists, doctors, optometrists, pharmacists, engineers, and economists procured by the SEC. Investment and financial advisors procured by the Treasury clearly fit within the definition, should be added to the code. I have the department representative here if you have questions.
Speak to the bill?
Let me see if you have questions.
Okay. Are there questions for the delegate or for our resident expert? Senator Reeves.
Thank you, Mr. Chairman. Question for Delegate Wiley. For a long time, I had my Series 6, 7, 63, and I had to be licensed. And it gives me a little pause when it says, and any investment financial advisor. Does it give you pause that we don't say, and any licensed investment and financial advisor?
I think it might be wise if that's amenable. I think that if we need to qualify that better.
I think that would be better, because then FINRA and some of the other organizations are going to. So if he'd consider that a friendly amendment, I'd ask to put in after, well, I don't have a line number, but any, put in licensed investment and financial advisor.
Okay, so the amendment offered by Senator Reeves is to add the word license after any on line 59. Is there a second to that amendment? Okay, motion and seconded. So first we'll vote on the amendment. All in favor of the amendment, please say aye.
Aye.
Aye. Any opposed? Okay, and then is there anyone waiting to speak against this particular bill? Okay, is there a motion?
Move to report and re-refer to finance.
Okay. Okay, the motion is to report and refer to finance as amended. Please signify your preference in the voting board.
Ayes 15, no 0.
Okay, that bill reports or recommends reporting
Thank you, Mr. Chairman.
to finance. Okay, now we have Delegate McQuinn. I know you've got
Thank you,
HB 1270. Do you have more than one, or is it just the 1270?
Beg your pardon?
Is that House Bill 1270, or do you have another one as well?
Yeah, House Bill 1270.
Okay, please proceed.
Yep. Thank you, Mr. Chair, and the members of the committee. House Bill 1270 is a bill that attempts to address some of the mold issue. It amends the Virginia Consumer Protection Act to add the sale of residential mold remediation without holding a certification from the Institute of Inspection, Cleaning, and Restoration to a list of unlawful practices. And what has happened that individuals have been sent in when there's been mold in the homes of or in residential areas of individuals, and they have not had a certification, so it wasn't properly done. And this continued to happen over and over again. Mold is prevalent in the Richmond area, particularly, as a matter of fact, the Richmond area is ranking number 7 as it relates to mold, and just and so many individuals are being affected by it, asthma issues and many other things that are going on. So this helps to hopefully hold landlords responsible for existence of mold and for making sure that the repair is adequate when they are asked to respond to it.
Thank you for this. Is the Institute of Inspection, Cleaning, and Restoration certification widely available and a national certification?
There is certification and that is available, and under this, the Department of Virginia, information would go to the Virginia Housing Commission, but it will be taken care of through those kind of programs to make sure that it's being done and done properly.
Okay. Thank you. Is there any other questions for Delegate McQuinn? Senator Rome.
Thank you, Mr. Chairman. Mr. Chairman, question for the patron on lines 225, 226. There's a reenactment clause on this.
I mean, yes.
Right, and so, Mr. Chair, my question for the patron, two questions, and is one, how did the reenactment clause actually come to be in the first place on it? And then second, would the delegate consider it a friendly amendment to not have it? Because this seems, mold is just, that's a public health hazard, and I would hope we could get this expedited.
Absolutely. Yes, absolutely. I would accept that.
So, Mr. Chair, I was wondering, follow-up question, Mr. Chair.
Please, go ahead.
Thank you, Mr. Chair. Mr. Chair, could the patron speak to how the reenactment clause came to be in the first place?
It is my understanding, can I get someone to, who here to speak to it, do you know? Okay. In terms of the reenactment clause.
So I wasn't a part of the reenactment clause conversation, but if we are going to amend it to take the enactment clause out of there, I would also suggest removing the word specialist in the language as well. And the reason I'm saying that is because the IICRC, by the way, Robbie Bradshaw on behalf of the IICRC, the IICRC has 2 certifications that deal with mold remediation. One is the AMRT, Applied Microbial Remediation Technician certification. There's already 400 some people in Virginia that have that certification, so they would automatically comply with it tomorrow if this was enacted. The mold remediation specialist certification is a brand new certification we have, and all it is an exam, and there's really not that many people that do it. So you would kind of be putting people in a bind. The IICRC would be fine with removing the enactment clause and removing the word specialist in order to not screw over a bunch of restorers who are compliant with it already.
Mr. Chairman.
Yes, Senator Rum.
Thank you, Mr. Chairman. Mr. Chairman, I would move accordingly to strike the reenactment clause and to take up, as the witness just said, and to include that amendment as well.
Okay, so that would be on line 218 to remove specialist and then to delete lines 225 and 226. As a motion, is there a second? Second. And a second. Okay, all in favor, please say aye. Aye. Any opposed? Okay, so we now have the amended bill before us. Is there anyone here to speak against this? Okay, is there a motion?
Move to report as amended.
Okay, there's a motion and a second to report as amended. Please signify your preference on the voting board.
Ayes 15, no zero.
Thank you.
Thank you, Mr. Chair, members of the committee.
You're welcome. Delegate Williams. And then after Delegate Williams, we'll hear from Delegate Lopez, Srinivasan, Bennett Parker, and Anthony.
Hello.
Good afternoon.
How are you?
Good, thanks. What's your bill number?
I'm looking for it as well. 852. 852.
852. We'll direct our attention to HB 852 regarding to local government ordinances related to fire departments and billing on behalf of volunteer fire departments.
Yes, thank you. This bill is brought to me by local fire departments, volunteer fire departments specifically across the Commonwealth, who are struggling with financing and recruitment. And this bill would allow those volunteer fire departments that provide EMS services when they come out, say like a car wreck or something like that, then they would be able to bill for those services, EMS services that a volunteer fire department would provide. This would allow the governing body in the county, city, or town to create that ordinance.
And that would allow them to qualify for health insurance reimbursement as well as other?
That's right.
Okay. Are there any questions for Delegate Williams?
I do, Mr. Chair.
Yes, Senator Rouse.
Delegate Williams, so is there, City of Virginia Beach has the largest volunteer first responders, firefighters, EMS service in the country. And so what prevents the city now from adopting an ordinance to where they can charge for services? I'm just not understanding or clear. I know our sister cities and surrounding cities, they can charge for services, but is this just specifically targeting firefighters?
Yeah, I might defer to staff. It appeared in the code section that, city fire departments and paid fire departments and things like that could pass ordinance for billing property owners, but it was the fact that volunteer fire departments were not able to bill specifically for emergency medical services.
I think if that completes your question, Senator McPike had a question, then we'll hear from Delegate Rome.
Yeah, Mr. Chair, I think the answer to the previous question is many of them are organized under one organizing department and therefore billing. Some of these, I think what the delegate's trying to address is some of them are standalone. So what this is doing is delegating authority, because some departments operate almost independently under a service agreement to the county. And so I think what he's doing is trying to attach the two. So a lot of localities already do it in terms of a unified billing system. I think it's trying to address where you might have different components that are somewhat detached, but allowing the county to do that.
Okay, is there anyone waiting to speak against HB 852 in the room? Anyone who feels compelled who would like to weigh in support, either online or in the room? Okay. Is there a motion? Oh, I'm sorry, Senator Rome, I didn't come back.
Thank you, Mr. Chair. A question for the patron. All right, thank you, Mr. Chair. So in a very similar way to the last bill, I don't know what's happening in the House. This one also has a reenactment clause. Would the patron be able to speak to that and why we have this?
Yeah. Mr. Chair, Delegate Simon is the chair of Civil Sub. I'm kidding. But he put that on. There's two of my bills that have that, and basically we were working on the concern of what the definition of billing was. One of my other bills, we were also trying to get the terms right. Good bill to move through, wanted to get it right. The idea that this could come off later. That was the idea.
Okay, Mr. Chair, then I would move to strike lines 22 and 23, striking the reenactment clause. And if there's any further issues, I suppose the delegate could just simply put into conference.
Yeah, that's fine with me.
Okay, Senator Locke has a question.
Oh, I made a motion, Mr. Chair.
Oh, I'm sorry, your motion was to remove the reenactment clause, and I think, is there a second to that?
I think Senator Locke had a question pertaining to that.
Yeah, we're going to take that before we vote. Was there a second on your motion? Okay. There's a second. Now, Senator Locke wanted to address that. Senator Locke?
If we remove the reenactment clause, does that put a fiscal impact on this bill?
There was no physical impact to begin with. I don't think there will be another fiscal impact.
Okay.
I guess my question.
Senator Rouse.
Mr. Chair, my question would be, why was there enactment on this in the first place?
What? I'm
sorry. Why was, Mr. Chair?
Yes, Senator Rouse has a question.
Why was there a reenactment on this in the first place? Before we removed something, I'd like to know why was it placed on there to begin with?
Mr. Chair, there was a concern about the definition or word billing. And so I think that was what we were concerned about. We went and looked at that with the EMS providers, with the ambulance department, things like that. Okay. And so that was the concern, and thus we addressed that concern, I felt like, and thus we could take the enactment clause off was the idea. Again, I have a similar bill that's a little bit different. I mean, I don't know if you want to call the Delegate Simon. I don't know.
Delegate Simon, would you like to comment since you've been addressed?
Mr. Chair, what is the solution to the billing question? That would, yeah.
Here's the.
A little unusual, yes. As the proponent of the reenactment clause, I think we had we thought it was a good bill. There were some concerns that were raised by some of the stakeholders at our committee meeting about how billing would work. And if there's no one who's shown up at committee today that say they still have those concerns, and the patron's representing that he's worked with the stakeholders and everybody's comfortable with the language now, I don't think the House would object to having this removed, because we'll get a chance to look at it again when it comes back. But that was the reason was there were some stakeholders in the room that weren't sure how what billing would mean, and I think they've worked that out.
And we were going through a ton of bills really fast that particular day.
Are there any stakeholders here? This is your last call to address this bill if you're in the room. Okay. So there's a motion and a second to remove the reenactment clause on lines 22 and 23. All in favor of that, please say aye. Aye. Any opposed? Okay. Now we have the amended bill before us, HB 852.
Move to report as amended.
Okay. There's a motion and a second. We'll indicate our preference on the voting board. Okay.
Ayes 15, no zero.
Thank you, Delegate. Was that your last bill with this committee?
1351.
Oh, there's another one? Okay.
You have a sub?
HB 1351 is the ignition interlock systems bill.
You have a substitute?
Is there a substitute for this? Okay. Is there a motion to adopt the substitute?
So moved.
Moved and seconded, we adopt the substitute, which is already online. Please indicate your preference for the sub by saying either aye.
Aye.
Or otherwise say nay. Okay. Delegate, why don't you explain to us the substitute?
Yeah, so this bill was to eliminate one of the issues that we were having with ABC or base app in-nation interlock providers who may not be licensed or certified by the Commonwealth soliciting prior to conviction the use or installation of their ignition interlocks, and we didn't feel like that was very fair, but we wanted to make sure that we had the language right, so we worked with the Virginia ASAP program to make sure that we got the targeted advertising language correct instead of saying something that would have unintentionally stopped the Commonwealth of Virginia from being allowed to mail them something about interlock systems. So that's why there's been a pretty significant change in the language, which that's why there was an enactment clause on it as well to see if we could work this out rather than just dying for lack of language.
So the people in the industry who are licensed in Virginia are in support of this language?
Yeah, and so is the Virginia ASAP. They helped me with that language. I believe they're here. I would guess they would be.
Okay, if you're waiting to speak on this bill, please come forward and.
Yeah, he helped me draft the language.
Good afternoon, Mr. Chair, members of the committee. Christopher Morris with the Commission on ASAP staff. We do support this bill. What it does take care of, as Delegate Williams was talking about, is we canceled the contract of an ignition interlock vendor last year. Part of that was due to deceptive marketing practices. What they were doing was sending marketing targeted mailings to clients that had not yet been convicted but had been arrested of DUI, and it made them feel like they had to put an interlock in or they would be in trouble. And also it mirrored that it looked like it was coming from the state of Virginia. So this fixes both issues, and the reinstatement clause, when it was in the House, we were fearful of at the Commission was that it would go too far and the interlock vendors wouldn't be able to market to people that have actually been convicted of DUI. So the House put a reenactment clause on it. We worked with the AG's office and with Delegate Williams and got that ironed out.
Okay, thank you.
You're welcome.
Is there anyone waiting either in person or online who wanted to speak against this legislation? Okay, is there a discussion or a motion?
Mr. Chair.
Senator Rum.
So, thank you, Mr. Chair. A brief question for the patron.
Senator Rum.
Thank you, Mr. Chair. I just want to make sure that the substitute that we're looking at here, in its entirety, the only changes are lines 215 to 223. Reenactment clause been struck. And so it's just basically what's on page 9 right now. That's the only change in the bill. Is that correct?
Most likely, but I don't want to say, is that correct?
I'll defer to counsel.
That's correct. That's the only changes. Yeah.
Thank you. Thank you, Mr. Chair. Thank you, counsel.
Okay. Is there a motion or other questions?
Move to report substitute.
So Delegate Price was here. She helped me work on this, and that was one of the reasons the enactment clause was added to it. I'd hope that the enactment clause could come off of it if it hasn't already been taken off.
Yeah, it's off in the substitute.
Okay, thank you.
We can have it back on, though.
Okay,
I'd
so
rather
there's a motion to pass the substitute amendment in the nature of a substitute. Is there a second? In a second. All in favor, please signify by saying aye, or voting aye. I'm sorry, voting on the voting board.
He's got JCF.
Okay.
Ayes 14, no 0, 1 abstention.
Thank you, Mr. Chair and committee.
Thank you. The bill reports. Okay. Next, we have Delegate Lopez to be followed by Delegate Srinivasan, Delegate Bennett Parker, and others. Is Delegate Lopez here? Okay, well then let's hear from Delegate Srinivasan.
Good afternoon, Mr. Chairman and members of the committee. DLS has prepared a substitute.
This is 1519, and I understand there's a substitute. Thank you. Okay. Okay, why don't you explain this? Oh, first, let's adopt the substitute. Is there a motion and second? Okay, so all in favor of adopting the substitute, please signify by saying aye.
Aye.
Any opposed? Okay. This is the electronic fund transfer fee bill. Why don't you tell us about the substitute?
Thank you, Mr. Chairman. The first section of the substitute is a technical amendment that ensures the provision impacting consumer transactions subject to the Virginia Residential Landlord and Tenant Act is placed consistent with the current code practice. The second portion of the substitute excludes ATMs, automated teller machines, and services that expedite electronic funds transfer from the provisions of this bill. So it excludes ATM machines. HB 1519 is a consumer protection bill that seeks to prevent individuals from being charged a processing or a transaction fee for the purchase of a good or service, including payment of rent when using an electronic fund transfer known as EFT. Common examples of electronic fund transfer include direct deposit, automated clearinghouse transfers, and debit card transactions. This bill refers to EFTs as the term is defined by the Consumer Financial Protection Bureau. Some companies, including merchants and landlords, have begun to charge consumers fees on EFTs, passing the previously understood cost of business onto the consumer. In certain circumstances, these fees are unnecessary, as the companies charging them do not incur the cost underlying in the transaction. This bill does not impact banks or credit unions and does not prevent companies from assessing a processing fee on credit card transactions, as credit card companies too commonly have an interchange fee that costs businesses anywhere from 2 to 5%. Thank you for your consideration, and I'm happy to answer any questions from the committee.
Delegate Srinivasan. Okay, is there anyone waiting to testify on this bill in person or, yes, please come forward. If you're in support, please come forward. Okay, well, opposition then, if not. But first, let's hear the supporters. Okay, Mr. O'Connor, hi.
Good afternoon, Mike O'Connor with Virginia Petroleum and Convenience Marketers. Worked with the delegate, appreciate his time and the clarifying amendment that you see on line 266 that assures that this does not cover regular transactions that are withdrawals from ATM machines.
Okay,
Thank you.
Thank you.
This is just for
Mr. Chairman, Matt Benka with the Asian American Store Owners Association. We appreciate the delegate working with us on the substitute, which takes out the ATM portion of the bill. That's very important to us. So thank you, delegate.
So just to clarify, there's no fee for using an ATM machine or to get cash, but there's a prohibition on a fee from just paying at the register with your ATM card.
Yes. Yes.
Yes, Mr. Chairman. If I go buy a product, could be a bag of chips, and if it is $10, I can be charged 50 cents for it.
Okay.
Because it's a debit card.
Okay. Yes, please come forward.
Mr. Chairman, members of the committee, Nicole Brenner with Reed Smith. I'll just echo the earlier comments. Appreciate the patron working with us. The issue was when there might be a fee for an expedited transfer when that is the service, so not impacting the underlying intent of the bill. Appreciate the patron working with us.
Okay. Welcome.
Mr. Chairman, members of the committee, Clark Lewis, Troutman Pepper, representing the amusement operators of Virginia. Some of our members independently own ATM machines, and we appreciate the cooperation of the patron. Thank you.
Okay. And now, were there any waiting to speak in opposition? Come forward.
Mr. Chairman, members of the committee, Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We appreciate the intent of the bill. We weren't aware it was going to be amended on the House side, so we weren't able to testify, but we are strongly opposed to the bill. We're concerned about the statutory penalties that are involved with Virginia Consumer Protection Act violations. We worked on several bills this session on to address fees, including fee summary forms, and then Senator Evans and Delegate Tran's bill to make sure housing providers are implementing at least one mode of payment that does not have a fee, which we believe addresses that concern that the delegate has and the intent of the bill. We have companies that charge our members a fee, and so our members transfer that fee that they're charged, but it's not a moneymaker for our industry by any means. So the penalties under this act are really substantial, and they're for every occurrence. We're very strongly opposed to this bill. Thank you. Sure.
Fee that you incur when someone pays with a card?
I know it's it really depends on what mode of payment that is. I don't have an answer for that question.
With the debit card, yeah.
Yeah, I don't have an answer, but.
Okay.
Mr. Chair, Erin Corman with the Realtors. For the reasons already stated, we've worked on several fees transparency bills this session already where all the stakeholders are in agreement. I'm just looking at the amendment. I see that there's now added language to the Landlord-Tenant Act. I think the intent of that language has already been addressed in Senator Boysko's bill. So we respectfully oppose the language as written. With respect to your question, though, the fees that are charged are fees that the bank is charging the landlord for any kind of ACH deposit into the account. And if the landlord could potentially pass that fee on to the tenant. So we don't have landlords like Aoba said, we don't have landlords that are charging money, trying to make money off tenants. We're just passing on, if we even do it, we're just passing on the same fee that the bank is charging us.
Do you know what that fee is?
I don't, because I think it depends by bank.
Okay.
But all of those fees would have to be disclosed under all of these other bills that have already gone through, and we would have to provide a method of payment that does not have an additional fee attached to it.
Okay, thank you.
Thank you.
Are there members of the committee with questions for the delegate? Are there motions?
Move to report the substitute.
Okay, there's a motion to report the substitute in a second. Please indicate your preference on the voting board.
Ayes 11, noes 4.
Okay, thank you.
Thank you, Mr. Chairman and
Sure,
Company.
thanks. Okay, now we've got Delegate Bennett Parker.
Thank you, Mr. Chair. I have two bills before you. HB 1398 is one of them.
Okay, HB 1398.
House Bill 1398 adds a tool in the toolbox to help us address Virginia's affordable housing crisis and keep our existing affordable housing inventory. When a multifamily rental building with 10 or more units has received state or federal assistance to create affordable units, those affordability restrictions are expiring, and the owner intends to sell the building to a third party, the bill would allow localities or their designee to establish a right of first refusal if they can match the third party offer. The owner receives the same purchase price and the housing remains affordable. The locality or designee cannot provide a matching offer, the owner sells to a third party. These are buildings that have already received public assistance from taxpayers, so this is a simple way to make sure that our public investment in affordable housing is maintained. More than 6,000 publicly supported
Can you slow that down just a little bit? So,
Yes, sir, Madam Chair. Sorry, Mr. Chair. It's been a very long day. So this is to create a tool in the toolbox to help us preserve our affordable housing inventory. When a multifamily rental building with 10 or more units has received state or federal assistance to create affordable units, those affordability restrictions are expiring, and the owner intends to sell the building to a third party. The bill would allow localities or their designee to establish a right of first refusal if they can match the third party offer. The owner receives the same purchase price and the housing remains affordable. The locality or designee cannot provide a matching offer. The owner sells to a third party. These are buildings that have already received public assistance from taxpayers, so this is a simple way to make sure that our public investment in affordable housing is maintained. More than 6,000 publicly supported affordable rental units are at risk of losing their affordability in the next 5 years, and that number quadruples to more than 25,000 in the next 10 years. The bill is supported by the Virginia Housing Alliance, Habitat for Humanity Virginia, National Housing Trust, the Partnership for Housing Affordability, Project Homes, the Virginia Association of Housing and Community Development Officials, the Virginia Statewide Community Land Trust, the Maggie Walker Community Land Trust, Virginia Poverty Law Center, among others. Thank you, Mr. Chair.
Thank you. So this is a local option, and are all those people waiting to speak in support? If you want to come forward and identify your organization and anything you have to add, we're trying to expedite if we can.
Mr. Chair, thank you. Isabel McLean with the Virginia Housing Alliance. We strongly support this bill, and we're really grateful to the patron for bringing it. Essentially, this bill gives localities a tool to ensure that our state and federal dollars that have gone into affordable housing can continue to benefit Virginians and continue to help us address the affordable housing crisis. Thank you.
Thank you. Welcome.
Mr. Chair, members of the committee, Sheila Herlihy with the Virginia Interfaith Center for Public Policy. We also support this bill because it does allow a framework for members of our faith communities to find affordable housing. Thank you.
Thank you.
Thank you, Mr. Chair, members of the committee. Larissa Zare with Legal Aid Justice Center. I'll associate my remarks with the previous folks, and we support the bill for the same reasons. Thank you.
Thank you.
Hello, Mr. Chair, members of the committee. Christy Mara with the Virginia Poverty Law Center. We also support the bill for the reasons previously stated. Thank you.
Thank you. Are there any, either in person or online, in opposition to HB 1398? Okay. Is there questions or motions from members of the committee?
Move to report.
Second. There's a motion and a second to report this bill. Please indicate your preference on the voting board.
Ayes 9, noes 4, 2 abstentions.
Okay. And do you have one more bill? Okay.
I do, Mr. Chair. House Bill 442.
Okay, we'll direct our attention to House Bill 442.
Thank you, Mr. Chair. This bill will offer certain tenants who owe no more than 1 month of rent a chance to pay their debt through a payment plan before they're taken to court for a judgment. If a tenant were to miss a payment on their plan under this bill, or if they were to miss a subsequent rent payment while on the plan, the landlord would still be able to move forward with the judgment. Additionally, only one payment plan is allowed per lease term, so this cannot be a recurring situation. Too often, tenants live paycheck to paycheck, and all it takes is one unexpected medical emergency or car repair to impact someone's ability to make a timely rent payment and go from having a stable home to facing eviction proceedings. You may hear that payment plans don't work, but when they have failed, they failed because the amount owed by the tenant is insurmountable, often exceeding $5,000. This bill differs from the payment plans that were in place during the pandemic because it is limited in financial scope to tenants who need help with only 1 month of rent or less. And again, it cannot be a recurring situation. It can only be used once. The bill will help Virginia's families and children experiencing a temporary hardship remain housed. And I know there's folks here to speak in support as well. Thank you, Mr. Chair.
Okay, with those who are here to speak in support, please come forward, and maybe we could put 2 minutes on the clock.
Thank you, Mr. Chairman, members of the committee. Christy Mara with the Virginia Poverty Law Center speaking in support of the bill. And I want to reiterate something that the delegate said. This is not the same payment plan bill that you all used as a temporary measure during the pandemic. This is only going to be available to people who owe 1 month's rent or less. And these are the very people who are able to benefit from a payment plan and who, without a payment plan, may fall into deeper poverty as a result of an eviction and of a court case and of all the additional fees that those things cause people to have to pay. And so we urge you to pass this very, very limited and also very common sense and helpful measure. Virginia still has the highest rate of eviction filings in the nation, despite everything that you all have done over the past few years, and you have done a lot to protect tenants from eviction. So please, we urge you to vote yes.
Thank you, Mr. Chair, members of the committee. Larissa, once again, with Legal Aid Justice Center. As a legal services attorney, I and my colleagues regularly represent tenants in eviction actions where they owe 1 month of rent or less. The situation gets exponentially harder to recover from once a tenant is in court, owing even a small amount of rent. Then they would need to owe court costs and attorney's fees associated. They also miss work and would lose income when they're summoned to court. A 1 month of rent is the most likely, or is the amount that a tenant is most likely to actually be able to pay, and this means landlords would be receiving more payments and also avoiding court and judgments that can be difficult to collect. So we would urge you to please vote in support of the bill. Thank you.
Welcome.
Sheila with the Virginia Interfaith Center. We support the bill for all the reasons stated.
Thank you.
Isabel McLean with Virginia Housing Alliance, and we also support the bill for the reasons stated.
Okay. Before we turn to opponents, I just wanted to ask what happens if the tenant does not enter into a payment plan within 5 days of receiving notice that they are eligible because they've fallen behind?
I believe the landlord could proceed.
With eviction?
Yes.
Okay. Okay, and those who are opposed to HB 442? Welcome.
Well, thank you, Mr. Chairman, members of the committee. Bisma Ahmed with the Apartment and Office Building Association and the Virginia Apartment Management Association. We worked on several housing bills this year to come to compromise language. This is one that unfortunately we could not come to. It's the number one bill of concern this session for our members. It's something that our members are offering on a voluntary basis already, especially, for tenants with a strong rental history. We want to keep folks housed. However, when this was implemented on a temporary basis during the COVID pandemic, we saw roughly 60% default rate. And so this was at a time when there was a lot of rental assistance. The RRP program was in effect. And so for that 60% that did face eviction, there's a higher monetary judgment and elongated amount of time. And, we're already seeing a 2 to 4 month timeline on an eviction process. So this is delaying it another 30 days in those cases of default. Especially since, we're also proposing to increase the pay or quit notice to 14 days this year. In 2020, we enacted the unlimited right of redemption. So a tenant can come 48 hours prior to a scheduled eviction and cancel that if they pay in full. We also worked last year to have the courts track, what tools are working, how many evictions are actually taking place. So as you know, rental housing is a single industry, single revenue industry. So, if we don't have that timely rent, we need to fund the mortgage, payroll, utilities, taxes, maintenance, renovation costs. And this is particularly heightened in market rate affordable housing where the margins are already razor thin. So we ask that you oppose the bill. Thank you so much.
Thank you.
Mr. Chairman, members of the committee, Zach Lemaster with Gentry Lock here on behalf of the Northern Virginia Apartment Association, who has 100,000 dwelling units in Northern Virginia, and we would associate our comment to the previous speaker. Thank you.
Thank you. Okay. Did you want to wrap it up unless there are questions?
Yes, thank you, Mr. Chair. I would again reiterate this differentiates from the payment plans offered during the pandemic because of the limit in scope and that it cannot be used multiple times. Additionally, almost half of the eviction judgments entered across Virginia were for amounts less than the statewide median gross monthly rent, or about $1,200. An eviction judgment remains on a person's record indefinitely, even after it has been paid off, and can prevent that person from obtaining safe, secure housing for years after the judgment is entered. So I hope the committee will support the bill. Thank you.
Thank you. Okay, are there questions or motions on HB 442?
Move to report.
There's a motion and a second to report HB 442. Please indicate your preference on the voting board.
Ayes 9, no 6.
Thank you. Okay, that bill reports, and next we have Delegate Anthony, then Delegate Lopez, then Delegate Hodges, and Delegate Ennis. Is Delegate Simon in the queue? I can't see that far down. I'm sorry. Okay. We'll call you, Delegate. Sorry.
Thank you, Mr. Chair and members of the committee. I have HB 996, which is the front end of the Virginia Residential Landlord-Tenant Act. Will create transparency in the rental application process by requiring housing providers to disclose upfront their application fees and eligibility criteria that will result in automatic denial of the applicant. It also will require housing providers to give denied applicants notice of the reason for the denial. It also avoids unintended discrimination by requiring the landlord to review the rental applications in the order that it was received. I hope it be the will of the committee to report. Thank you.
Thank you. Are there those waiting to speak in support of HB 996? Please come forward.
Chairman, members of the committee, Laura Dodds with Housing Opportunities Made Equal. I thank the patron for bringing this basic transparency measure, and we support the bill. Thank you.
Mr. Chairman, members of the committee, Christy Mara with the Virginia Poverty Law Center, and we also support the bill.
Sheila Herlihy with the Virginia Interfaith Center for Public Policy. We also support the bill and thank the patron for bringing it.
Hello again, Mr. Chair, members of the committee, Isabel McLean, thank you, with the Virginia Housing Alliance, and we also support the bill.
Thank you.
Thank you, Mr. Chair, members of the committee. Larissa Zaire with Legal Aid Justice Center. We also support the bill. Thank you.
Thank you. Welcome.
Kashish with New Virginia Majority, and we also support this bill. Thank you.
Thank you. Is there anyone in opposition to the bill or anyone waiting online with the view? Okay. There's a question from Delegate von Valkenburg.
Yes, thank you, Mr. Chair. I mean, I like the bill. I guess I'm a little, I don't know what the right word is, wondering how lines 146 to 167 would work in practice. So it says, if after receiving an application, the landlord takes an adverse action, the landlord shall send notice to the applicant pursuant to blah, 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 including a written statement of the reasons for such adverse action. So, if you're in the Richmond market where housing is in real short supply and you get a lot of applicants for the apartment, and then you have to send each one of them a letter with the written reasons why, which I would assume would, I guess you could automate, but I guess I'm wondering how that works in practice.
I think because we've worked with a lot of folks, I particularly work with a lot of constituents who did not receive any kind of notice, and this allows applicants that if they did receive an adverse action, that they can be able to correct those errors in their consumer report. And I will yield to some of our stakeholders. Thanks.
Okay. Did anyone else want to comment on that? Okay. Yes.
Mr.
I think I've got, you want to follow up, Delegate von Valkenburg?
Yeah, if I can.
Go
Can
ahead.
a stakeholder talk about that maybe? Because I guess, maybe I'm using teacher brain here, but when you say include a written statement for the reasons for such adverse action, and if we have 100 people, that might be a incredibly hyperbolic number. But if we're talking about a large number of people that are applying to an apartment that you're then reporting the written statement for, like I said, I like the underlying bill. I'm just wondering about this one line about how that, what that would look like in practice. Mm-hmm. A written statement, because ostensibly, as I read it, you would probably have to write a different written statement for each person.
Chairman, Senator Van Valkenburg, it could even be if you rented the apartment to someone else and filled the unit, it could simply be we rented the unit to someone else. And that written statement doesn't have to just be a mailing, it could also be an email.
Question? Let me turn to Senator Reeves.
Thank you. Delegate, I'm just trying to track this. So if I'm looking for an apartment and there's a line of people that want that apartment or that house, especially single-family homes, if I don't have, I don't know how it's going to be workable, because when you put in the application, they're trying to go through that process. And for a lot of those folks, they use that fee to run your credit report and all the other things. So this is saying you got to do all that before you even get there. I don't understand how that's workable. And if you don't have the deposit, it's not a complete application, then can you get dumped out of the pool to get the house if you don't have the, I get what you're trying to get at. I just don't know how you get there. I guess my question is, how do you get there?
Mr. Chairman, I would ask Senator, is he asking that the transparency and the fees? I'm not sure the line of questioning.
Mr. Chairman, let me try to rephrase this. As an applicant, I'm asking the landlord to trust but verify when he's got a list of people. Is what the way I interpret this now is I go through everything here. They've got to check it all out, and then I don't see how the landlord makes it workable. I guess I don't have a question. I'll just vote my conscience.
Delegate Rome in the queue, and then Senator Rouse.
Thank you, Mr. Chair. I have just a question for the patron.
Okay, please.
All right, thank you, Mr. Chair. Mr. Chair, I would ask the patron then between lines 159 and 160, if where it says landlord shall notify applicants in writing or post in a conspicuous manner, that or post in a conspicuous manner, because we're not dealing with public notice in this case, so therefore not printed, that could be something that is as simple as putting it on, the online site where you have the rental, application in the first place, or where the property listing is in the first place. Would that not qualify in this case and be able to assuage the concerns that were expressed from the two senators?
No, I'm talking about a different part.
Okay.
Yeah, for him.
Chairman, members of the committee, if I may, that's the intent, that they could post on their website where they have the listing of what those basic criteria are. And I'll say too that they can charge a non-refundable application fee in addition to the cost for running the tenant screening report. And recently TransUnion, one of the major tenant screening companies, is going to be releasing a form that's like a checklist that they could, the housing provider could check out for the reason for denial, whether it's because of someone's criminal record history, their credit report, if their income's not high enough, or they have an eviction case, or if they simply rented the unit to someone else. So those landlords could look to that forms that are already out there in the market.
And Mr. Chairman, follow up.
Senator Rome.
So follow up, speaking to the bill in a way, we've done something like this with, say, when we were passing my bill to require local school boards to post in a conspicuous manner online free and reduced meal applications, for example. And so we've got existing precedent for using this style of language in the code. It's just that I think the way I'm interpreting it is we're just kind of applying it to a different, sector of the world.
Senator Rouse.
Yes, Mr. Chair, thank you. I don't know if it may help or not if the patron would consider a friendly amendment just on line 167, where it says including a written statement. If we just add the word via electronically or mail, would that help or no? Because I hear that if you get a 60 or 30 applications that they would have to respond within 14 days. And I heard one of the pages say that can be by email, but I don't know if we need to define that in the language or not.
Yeah, Mr. Chair.
Yes, Delegate von Valkenburg.
Yeah, I guess my angst about line 167 is just that feels like a lot of work on that back end, where if we're just saying, I think they should be told they didn't get it. So I guess I don't want to prolong this longer than we need to, but do apartment folks not already do lines 164 and 165, which is to tell people that they have not accepted them? Because if they don't, they should. But I guess my thing is, I think telling them that they didn't get it is enough, and I don't like the idea of having to write out an essay for every person that they rejected. I think that's burdensome, and I don't support that. I support the bill. I don't think I support that provision of the bill.
Mr. Chair.
Yes, Delegate.
Thank you, Mr. Chair. So that basically, under law, they already have to provide an adverse action notice. This also includes language to say why there was adverse actions and to give complete transparency to the applicant.
Okay. Were you going to comment as well?
This is Phone a Friend. Mr. Chair, Erin Corman with the Realtors. Just our members already have to do adverse action notices under the federal law, and in almost all cases have to say why that person was denied. And they're already doing this, and it's just a checklist, and they just check a box and indicate why the person was denied and send it off.
Okay. Thank you. Mm-hmm. Okay, so is there a motion or further comments?
Move to report, Mr. Chairman.
Okay, motion and second to report HB 996. All in favor, please indicate on the voting board. Otherwise, the same.
Did you take opposition?
Was there any opposition to this bill? I don't think did we hear from anyone? I think you had. Okay.
Ayes 9, no 6.
Okay.
Thank you.
Thank you. Okay. So Delegate Lopez, you're next, and then we'll come to Delegate Hodges. Yeah, 15 minutes.
Good afternoon, Mr. Chairman, members of the committee.
What's your bill number, sir?
I have three bills, 955, 957, and 950. Maybe we can do 955 first.
Okay. We'll direct our attention to House Bill 955.
Thank you, Mr. Chairman. This bill is about making sure tenants know what they are signing up for. For many Virginians, that can only be achieved by providing them key provisions of the lease in their native language. HB 955 simply requires the Department of Housing and Community Development to create standard cover page forms in the languages that the Commonwealth generally provides documents in. Landlords who manage more than 4 units would then, upon request, be required to fill out these out and include them with their leases in order to help prospective tenants understand what is in the actual lease. That's the bill, Mr. Chairman, and was worked on extensively by folks for some edits on the House side, and I hope that's the will of the committee to pass the bill.
Okay. Are there questions for Delegate Lopez before we turn to public comment?
Mr. Chair.
Yes. Senator
Maybe
Van
this is for
Valkenburg.
council. How does this interact with the bill that we just passed?
No.
Is there a conflict, Joanne, with the? Okay, yeah, I don't see a conflict. This is requiring a summary page and also the ability to have summary pages in other language that are model summaries drafted by the director of the Department of Housing and Community Development. Are there those here who would like to speak in support of this legislation, HB 955? Be mindful, we're trying to get back by 4:30, so if you could be.
Sarah Taylor, City of Alexandria, we support the bill.
Thank you.
Thank you, Mr. Chair. Larissa Zare, Legal Aid Justice Center, we support the bill.
Thank you.
Sheila Hurley, Virginia Interfaith Center, also support the bill.
Okay. Is there anyone waiting to speak against HB 955?
Move to report, Mr. Chairman.
Okay, there's a motion and a second to report HB 955. Unless there's questions, we'll indicate our preference on the voting board.
Ayes 9, no 6.
Thank you, Mr. Chairman. Can we go to HB 957 now?
Yes.
Thank you, Mr. Chairman. In Virginia, it's possible to be evicted without going through the usual eviction process. When a rental unit is condemned due to a landlord's severe neglect and inability to properly care for that unit, the tenant can be removed. This effectively amounts to an eviction. Under Virginia law, landlords have a very clear responsibility to make repairs and other types of general maintenance to ensure that a building and its rental units are safe, healthy, and habitable. When landlords completely ignore that duty to help to keep a building and its rental units safe, clean, and habitable, a rental unit can be condemned. And when a rental unit is condemned, a tenant has no legal recourse. What this bill does is provide a clear legal remedy for tenants who lose their homes through this form of eviction that is often the result of a landlord's extreme neglect of a property. HB 957 ensures landlords pay actual damages. Tenants get their rent and security deposit returned in cases where they are forced out due to a condemnation, with some exceptions. For one, the condemnation of the dwelling unit was caused by the deliberate or negligent act or omission of the tenant, an authorized occupant, or a guest or invitee of the tenant. And two, the condemnation of the dwelling unit was caused by an act of God. Or three, the lease was properly terminated pursuant to 55.1. Mr. Chair, I hope the committee passes the bill.
Thank you. Okay, are there any questions for Delegate Lopez? There's a motion second to report. Is there anyone in the public in opposition to this legislation? Okay, I see some people cheering on in the background. We have a motion and a second. Any other discussion? Okay, we'll vote on the voting board.
Ayes 12, noes 3.
Okay.
Thank you, Mr. Chairman.
And that completes yours?
One more.
Okay.
One more. Thank you, Mr. Chairman. Mr. Chairman, this bill is HB 950. Recently, the Board of Housing and Community Development has been told by the governor to remove a quarter of its rules from our building code, 25%. These are the rules that protect homes and businesses against fires, bad weather, and shoddy workmanship. The board just completed its triennial update of the Virginia Building Code. If there was a compelling need to remove regulations, one would believe it would have been done then. Housing advocates worried that the administration might especially target energy efficiency requirements, but nothing would stop them from cutting basic safety measures. This bill states that the governor and the Board of Housing and Community Development shall not modify or change any regulations touching the state building code before the next triennial review process for the Virginia Building Code is completed. The regular building code review is the right forum to discuss what, if anything, should be removed from the building code. This bill is supported by a broad coalition of folks, including some of the home builders, and I hope it's the will of the committee to pass the bill.
Okay. Do we have those who want to weigh in and support in the room? Please come forward. And is there anyone waiting online on this particular bill? Okay, please.
Mr. Chairman, Andrew Clark with the Home Builders Association of Virginia, and like the delegate said, we do strongly support the bill. Really affirms what we believe that the responsibility of the Board of Housing and the Board of Housing alone should be to promulgate a very technical document like the building code. So we hope you support it. Thank you.
Thank you. Okay.
Mr. Chairman, members of the committee, Bob Shippey with Sierra Club, we support the bill as well.
Thank you. Okay. Are there any other questions for Delegate Lopez or anyone who wants to weigh in against this legislation?
Move to report, Mr. Chairman.
Excuse me, Delegate Senator Rome?
Move to report, Mr. Chairman.
Okay, there's a motion, and is there a second? A motion and a second to report HB 950. Please indicate your preference on the voting board.
Thank you, Mr. Chairman, members of the committee. Greatly appreciate it.
Thank you. Okay, we've got 8 minutes left. Our next in the queue is Delegate Hodges and then Delegate Ennis. And we'll preserve this queue for when we recess and come back. I'd rather get the delegate who's been waiting first. Yeah. Hi.
Hi, Mr. Chairman. Thank you very much. You have before you House Bill 1430. King and Queen, like many other counties across the state, they recognize the need for a more streamlined and efficient approach to governing its public services. So in line with the vision, the county wishes to operate its public library as a department of the county rather than being governed by a separate administrative board. I can get into the details, but it will really help the county be able to bring these services in-house instead of being under an administrative board. They'll have an advisory board. They're having a hard time filling those positions. The regional library would have to vote unanimously to let them out of this.
Who would govern the libraries then?
Sir?
The local government would govern the library?
The local government passed the resolution, is actually requesting this, King and Queen County. So the county's 6,700 people, 72 miles, 8 miles wide. They can do it much more efficiently in-house.
Okay, and I guess other localities are doing this. Yes, to the list of localities. Okay, are there, I think I heard a motion. Is there anyone against this legislation? There's a motion to report, and is there a second? Do we have a motion and a second? And if is there any further discussion among members of the committee? Okay, we'll proceed to vote. Okay. We've got to go back to.
Thank you, Mr. Chairman.
Thank you. That reports. We've got to go back to the floor, but just for the patrons who are waiting, when we get back, we'll take Delegate Ennis, Delaney, Simon, and Maldonado in that order, and there's apparently 19 people waiting.
Just recessing.
Yeah, so we're going to recess until 5 minutes after the Senate adjourns or recesses next, and then we'll be back.
You got to come back.
The Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia. The Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B 306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia. Senate Committee Room, B306. This is the Senate of Virginia, Richmond, Virginia.
Again in just a moment. And whatever. Let's see. Let's see what we need to. Can you someone text Aaron or
You did that on purpose.
Oh, we got you.
You
Okay,
tried to
great.
injure me.
Let me just. Okay, the committee will come back to order. Delegate Ennis is next with House Bill 1182, and then will be Delegate Simon. Welcome.
Good evening, Mr. Chairman and members of the committee. House Bill 1182 makes a slight change to the voluntary certification requirements for Virginia's Professional Wetland Delineator certification to better align it with the Universal Licensing Recognition Statute, the URL. This bill will reduce the years of experience required to become a wetland delineator while keeping the education and training requirements as well as the required letters of recommendation. Under this bill, a prospective wetland delineator must have at least 3 years experience in wetland delineation or 3 years experience in wetland science research. This bill was the product of weeks of deliberation between my office, the Department of Professional and Occupational Regulation, and various wetland advocacy groups. The input of each group was vital to reach a final bill that we could all live and work with. I hope it is the pleasure of the committee to report this bill.
Mr. Chair.
Thank you. Senator McPike.
So I guess I would move to report the weeks of deliberation on changing one word from 3 to 4.
Okay, that's a motion. Is there a second to that motion? Second. Okay, there's a motion, a second. Is there anyone against HB 1182 who's here to speak against it? Anyone who wants to weigh in for it? Okay, there's a motion, a second to report the bill. Please indicate your preference on the vote. There's an amendment? No, the bill as submitted. Okay. Okay, so please vote on the board. If it was earlier in the evening, we would haze you, but we don't have time, so congratulations.
Thank you all very much.
Okay. Now we have Delegate Marcus Simon, who's been waiting patiently. Delegate...
That's not a problem. It's a visual aid, Senator Reeves. It's not allowed.
Delegate Simon, we heard the Senate cognated the bill. At that time, there was no opposition. I understand there are some who have other views now, but do you want to remind us about the bill? And
They should have come earlier.
Sure, Senator. This is identical to Senator Locke's bill, which says that localities can't have separate and distinct real estate disclosures, and that all the disclosures that we do in real estate in Virginia ought to be done through the Virginia Residential Property Disclosure Act. And so this says that no locality has the authority to establish mandatory disclosure requirements for real estate licensees, parties to the contract for sale or listing of the property, and other mandatory disclosures. The reason being, it's really impractical to have such a scheme. There's no remedy for a failure to disclose. Nobody knows what happens after that. There's really no authority over real estate agents and licensees in the zoning ordinance and other places, and so just think it's an inappropriate way to try and regulate the real estate industry. It ought to be done on a statewide basis through the Property Disclosure Act.
okay, thank you. We're going to take some testimony since there had been some folks who had differing views. Why don't we start with those against, and we'll put 2.5 minutes on the clock if we can do that. Yeah.
Mr. Chairman, members of the committee, Patrick Cushing on behalf of the Metropolitan Washington Airports Authority. We operate Dulles and Reagan airports, and we were not here for the Senate committee testimony, so apologize to the patrons on both bodies and the realtors. I know it's not great to come out of the woodworks late in the game, but the language of this bill, we actually don't have a problem with what it does, and it's been pitched as eliminating a patchwork of local real estate disclosures. And we agree that it does need to be moved into the state code. And I'm not saying that the patrons have agreed to that, but we have a problem because Loudoun County has had an ordinance in place for 30 years that has required disclosure on the initial sale of a home. About a year ago, it was amended to clarify some provisions that Loudoun had intended that would apply to subsequent sales of homes around Dulles Airport in an airport overlay district. That airport overlay district is developed under Part 150 of FAA guidelines. It is a noise map that looks at specific decibel readings on the approaches and on the takeoffs from Dulles Airport. We think part of being a good neighbor within the Loudoun community is making sure that residents understand when they move close to the airport, and if they're in a high noise area, there has to be transparency that they are moving into that high noise area. And so we've offered to the patrons and the realtors an amendment that would move this disclosure, because this bill only invalidates one local disclosure in the entire state, and it's Loudoun County around Dulles Airport. And so we've proposed moving this disclosure into the Real Estate Disclosure Act by amending the military air installation disclosure, which is very similar. Dulles is very similar to our federal military airports because of the size of jets that take off, the frequency, and the time of day. And so we think there's an easy middle ground solution. So that's what we would like to see as an amendment to get a disclosure in place for Dulles, even if it is for just 1 year. Well, we have the time to come back to a bill to present to this committee in the next session. I got others to speak. I'm sorry for taking so much time.
Sure. Mr. Chairman, members of the committee, I'm Edward Mullen with the Reed Smith Law Firm on behalf of United Airlines. Appreciate the patrons speaking with us and the proponents speaking with us. I'd endorse the MWA comments on discomfort with getting rid of this transparency, if not replacing it, at least temporarily at the state level. No problem with the facial purpose of the bill to avoid a patchwork. But again, I think in the interest of our neighbors knowing what they're getting themselves into in the short term, would ask for that consideration. Thank you very much.
Were there those who are waiting to speak in support from the realtors community or otherwise? Okay, and we have two online. Do we know if they're speaking in support or opposition? Okay, we'll take them last. Why don't you go ahead?
Okay, thank you, Mr. Chair, members of the committee. So despite what you've heard, this bill is not a statement about airports, airport noise, who should be told about airport noise, whether realtors like disclosures or don't. We've brought our own disclosure bills. This bill simply has to do with who has the power to establish mandatory real estate disclosures in the state. And historically, that power has always been with the State General Assembly, and we believe that that's where this power should lie. In 1992, this body set up the Virginia Residential Property Disclosure Act. That is where all the standardized language is with respect to disclosures. It lays out standard forms and all of the compliance information that allows realtors and licensees who have a legal obligation to inform their clients about disclosures. They can go there and find out how to comply. So yes, there is one in the entire state locality that has set up a mandatory real estate disclosure. And that disclosure has caused deals to fall apart because it doesn't have any standard forms. It doesn't have any compliance language attached to it. People don't know how to give the disclosure, they don't know how to find it, and they don't know when to give it. And that's why this power has to stay with a central statewide body and stay with DPOR and the Virginia Real Estate Board. If we allow localities to start setting up mandatory disclosures, yes, we're going to have a patchwork all around the state because every locality has issues that are important to them. If this bill were to pass as it is in front of you today without an amendment, it would not prevent any airport, Dulles, or any other airport that's not covered under this amendment, any locality, any association from bringing a disclosure bill before you. That is the method that should be used to set a mandatory real estate disclosure. With respect to the amendment, this bill, if it passed as it's in front of you today, would not prevent Loudoun County from going back to the ordinance that has worked for them for 29 years. It only prevents a mandatory disclosure from homeowner to homeowner. So just to make sure that everyone is clear, this is a bill that just has to do with the power of disclosure. It's a 15.2 bill. It doesn't have to do with 55.1 and what disclosures should or shouldn't be vetted by you. They did refer to the mandatory disclosure that has to do with Oceana and naval bases. There were years of study that went into that bill before it was brought before you. Years of noise studies, 150 safety studies done through the FAA, setting up local government websites where all homeowners could go, and it is set through DPOR with all of the standard compliance language. So we strongly urge you to support the bill as in front of you, not amended. Thank you.
I understand there were two people waiting to speak online. If you could unmute yourself and show yourself on camera, please begin your testimony.
Courtney Sindor, you can unmute and begin your testimony.
Thank you. My name is Courtney Sindor. I'm a senior deputy county attorney with Loudoun County, and I appreciate this time to speak to you this evening. I just want to talk with you a little bit about our airport impact overlay district and how we got to the point of updating the language in that district to require the disclosure at the point of resale. The district was initially established in 1992 or 1993 in partnership with Dulles Airport to protect the area around Dulles Airport. In part, restricts residential development, but in the areas where residential development is permitted, it requires various notifications, including notifications to prospective homeowners. The last speaker mentioned that this bill would not impact the version of the ordinance that has worked for Loudoun County for the past 20 some odd years. I think what I would say is that what we discovered is that it didn't necessarily work the way we thought it would, which is why the language was updated when we updated the otherwise updated the airport impact overlay district. We had a number of public hearings in 2022 before the Planning Commission and the Board of Supervisors. Excuse me, I personally sat through one of those public hearings, and I heard resident after resident after resident who came forward and talked about how the impact of the noise on their homes, the fact that they did not realize the impact of the noise on their homes, that either they did not receive notice of that noise impact or that they felt that noise impact was not meaningful. And so that is the reason why the board wanted to clarify the notice requirement and make sure that it applied not just to initial purchasers, but also to resale purchasers, and to try to make sure that people got meaningful notice before undertaking a very significant asset purchase. And so this is not something that was targeting realtors. We've tried to work, when realtors have come to us and asked us about the form of disclosure, what is required.
I'm going to ask you to sum up. We've got one more speaker, and we've had a few minutes for the opponents. If you could finish your testimony.
Sure, I'll just wrap up with that. If there are any questions, I'm happy to answer them.
Thank you. And we have one other speaker. If you could unmute yourself and begin your testimony.
Thank you, Mr. Chair. My name is Nick Sabo. I'm president of the Virginia Airport Operators Council. Appreciate all the comments tonight. I just want to also call attention to one consequence of this bill is that it prevents localities from enforcing real estate disclosure requirements that may have been agreed to in proffers for residential development near airports that have yet to be built. And we believe it's in our collective best interest, of course, to inform citizens about their proximity to airport operations, and disclosures are simply a best practice to achieve this. We don't have any heartache with the process and following this process. We appreciate all the comments and seeming agreement that airports should be disclosed. It's important to inform our citizens, but for these reasons, we must respectfully oppose this bill. Thank you, Mr. Chair.
Thank you. The committee has before us HB 467, and we have a few options. One would be to pass it as is, which would be to eliminate any local disclosure enforcement. The other would be to amend the bill to allow a year period until July 1st, 2025 for any local ordinance that's already in effect to be in effect while the Housing Commission looks at it. So that's the committee's choices. Unless there are others, we're open to discussion or motions at this point.
Mr. Chairman.
Yes, Senator Rome.
Thank you, Mr. Chairman. Question for the patron.
You could proceed.
Thank you, Mr. Chairman. So I would ask the patron, based on our conversation that we had earlier today, before we actually got to the committee and everything, the patron had mentioned that there could be kind of like another middle ground regarding we could have the sort of disclosure notification put into the tax record because, number one, that's updated every year. Number two, it's easily accessible from realtors because every realtor goes and has to pull up, tax records and everything. And so we might have some sort of middle ground. And I was wondering if the patron could speak to that and see if there's a way for us to deal with this. And Mr. Chair, just to kind of elaborate, what's happened since crossover, and I talked to Senator Locke, who's our Senate patron, about this earlier today as well, is in the city of Manassas, we have a unique issue in that we have an airport that's been around for a while, but they have just agreed on the city council last year to start allowing commercial service to go from Manassas Airport in, within the next probably year and a half from now. And so we already have noise issues that come from something unrelated to that in the greater Manassas area. But we absolutely have residential concerns about noise and specific to the airport. And since that's kind of a new issue that's been brought to our attention since crossover, I was hoping the delegate could, number one, address the preliminary issue about the tax record part, and then number two, speak to the concerns that my constituents would have.
So, thank you, Mr. Chairman, Senator Rome. My suggestion is, it's interesting. If you look at the county tax record in Loudoun County, they give you all kinds of information. They tell you if you're in an agricultural district, if so, how long it's going to continue to be in an agricultural district. They'll tell you whether you have an ADU or not. They'll tell you whether your property's eligible for a solar exemption, yes or no. And I'll tell you that every real estate agent in the Commonwealth, the first place they go when they're researching a property is they go look at the county tax assessment site to see what's on there, get that information. So my suggestion is that if they want to, since they make the overlay districts, and it's in every recorded subdivision plat and every lot knows whether or not, they could put that on the tax information page. They could make it red. They could have it blink and scroll and have confetti come out of it. But you can put that right there in the tax record for everybody to see. And so that puts the burden on the county to disclose to any prospective purchaser, anybody looking at the property, that it's an overlay zone. I think that would be appropriate. I think they have the authority to do that now. And I think if they're very concerned, they could do that as an interim step to really highlight the location inside the airport overlay district. I will also say that to the issue that of your airport, and also the issue that the realtors mentioned about Oceana, I've started, since this issue has been elevated and since it was in Loudoun now, to hear from homeowners in Loudoun County that are not thrilled with the maps that exist. They aren't thrilled with the way that they were arrived at. They're not thrilled with what they're being asked to disclose. They say that they're being asked to over-disclose for airport noise that doesn't exist yet and may never exist based on capacity versus an actual FAA sound study. So there's a lot to unpack there, and I think that sending it to the Housing Commission would do the trick.
Okay, so Senator Rome, did you have another question? I'm hearing a motion as well.
Well, speaking to the motion on that, I was going to ask and try to see if the committee has any interest in terms of the amendment that was proposed from Delegate Simon just now.
Mr. Mine wasn't an amendment. I suggesting that Loudoun County has the authority to do that and put it in their tax page right now. And they have to take advantage of that existing.
Yeah, I don't think he's suggesting an amendment. He's suggesting another course. Okay, so there was a motion to report HB 467.
This is an identical bill to Locke's bill, Senate 354, that passed unanimously out of committee in the House.
Right, we didn't hear any negative testimony at that time.
All right, just making sure everybody knows that.
Yeah, but we can, there's a motion to report, and yes, you want to speak to that motion?
Yes, I do.
Okay, Senator Locke.
The comments that we've heard today relative to Delegate Simon's bill, we heard on my bill on the House side, and my bill passed out of committee 21-1. So we heard that same testimony that we've heard here today on my bill. So I'm supporting the motion to report.
Unless there are further comments, we'll proceed to vote.
How do you vote?
Ayes 11, noes 3, 1 abstention.
Okay, the bill reports.
Thank you, members of the committee.
Thank you. Now, next in the queue is Delegate Maldonado, and I believe that your bill is the consumer. Is she here?
Mr. Chair.
Okay, yes.
I can take that.
Yeah. Okay, we're going to have Delegate von Valkenburg present that bill. It's a cognate to his.
Yeah, Mr. Chair, members of the committee, House Bill 707 is the same as my bill that passed out of this committee unanimously and passed the Senate unanimously around privacy, child privacy data online. It's the exact same.
In a second to report House Bill 707 as presented. Unless there's discussion, we'll proceed to vote.
Ayes 15, no 0.
Okay, next we have Delegate Price.
598.
Let's see. Welcome.
Yes, good evening, Mr. Chair and Senators. As you are well aware, the faces of the unhoused are rapidly changing and increasing, from working families with small children to our seniors. Evictions for non-payment of rent continue to put more families in jeopardy. I know you've heard quite a few measures today trying to help with this crisis, but we are indeed still in crisis. Evictions harm communities, prevent folks from obtaining safe and secure housing in the future, harms the health and mental health of residents, exacerbates chronic absenteeism of unhoused students, and more. When we were going through the pandemic, it exacerbated some of these issues, and we were able to put important safeguards in place. We were also hearing that some of the landlords were voluntarily putting some of these safety measures, I guess, safeguards in place. And so I was very transparent when we were passing those bills that one of the bills that I would try to bring back to make permanent was to increase from 5 to 14 the number of days for the pay or quit period. And so here I am. And basically it allows for renters to have the chance to get to their next source of income in order to catch up on rent before they go through the costly eviction proceedings. So House Bill 598 not only would increase that time from 5 to 7, it would also require renters receive written notice of the rent amount plus late fees, and it moves up the timing by the same number of days for the initial hearing on the summons for unlawful detainers for evictions due to non-payment of rent. We really strongly believe, based on what we've seen and based off what we know to be true, that the bill will help reduce the amount of evictions that Virginians are facing, to help hopefully clear up some of the court dockets that are really backing up from the evictions, make our communities healthier and safer. And I could go on.
Motion and a second to report HB 598.
Mr. Chair.
Senator McPike.
I'm not going to slow down the train. I'm going to support it. But in combination with the bills we just passed, we really need to look at it holistically. I don't like the way we've had dozens of bills in this code section. And I think we really need to do a better job in either subcommittee work in focusing through this, or sending these to a study as we start to really build a picture about the net impacts of now. We're doing 14 days for also payment plans and other things as we start to compile all these bills together. So I just hopefully we can take this a little bit more deliberately.
I
in the
think
future.
we'll consider a housing subcommittee next year if we get the same volume of housing bills. But there's a motion and a second in the meantime on HB 598. Yes.
Yeah, just
Senator Head.
Yeah, just real quick, if I could, on the page, because my understanding on this was I understand you're taking it from 5 to 14 days, but subsequently reducing the amount of time for filing the motion in court. I can't find that in the bill. Where is that? Because that that to me balances everything out.
Yeah, I just would love to make sure that we're looking at the substitute, because to be honest, the introduced version did not have that. Give me 1 second.
I have the House substitute in front of me, which I believe is what passed the
Yes.
House.
Yes, thank you. Well, depending upon your version, it's around lines 29 through 34.
Okay. Okay, Senator, your questions satisfied? Senator Head, you're done?
Yes,
Okay.
thank you, Mr. Chairman.
Okay, so we have a motion and a second. Was there anyone who wanted to speak against HB 598? Is here today? Please come forward.
Mr. Chairman, members of the committee, my name is Brandy Singleton. I'm with the Office of the Executive Secretary. We are the administrative offices for the state trial court system. I want to be very clear that the only thing I am speaking against is the shortening of that time within which these cases must be heard after filing. Under current law, these cases are to be heard within 21 days of filing, but no more than 30. Also, under current law, a tenant has to receive notice, has to receive service of process for his hearing date at least 10 days prior to the hearing date. When you foreshorten this to 14 days, It simply can't be done. You cannot get that filed in the clerk's office, processed by the clerk's office, served by the sheriff, and the return of service made back in time for the tenant to get 10 days notice and the case to be heard within 14 days. That's simply not possible under the current structure of the statute. So what's going to end up happening is if you set that return date at an earlier date, when everyone gets to court, there won't be proper service and it'll have to be continued out, likely to a date that is outside of the current 21 to 30-day period. This is simply a workability issue for the courts, and that is all I'm asking you to consider is striking those provisions in 8.01, 126 from the bill. Thank you.
Yes, Senator Locke has a question.
You're asking to strike the increase from 5 days to 14 days?
No, just the opposite. We have no issue with that. That's a policy matter for the body. I'm asking you to strike the court process piece that says the court has to hear the case within 14, but no more than 21 days, because that's the time frame that's almost impossible for the courts to meet.
So lines 27, that's where you have an issue where it changes 21 to 14 on that line?
That is correct.
And also on line 28.
It's really all the changes that are made to 8.01, 126. Those are the only changes made to that statute by this bill.
Okay, thank you. Are there others?
Mr. Chairman, members of the committee, I'll be brief because we've had this bill the last couple of years. Zach Lemaster with Gentry Locke here on behalf of the Northern Virginia Apartment Association, and we're opposed to the bill. The underlying bill, and in part because of the issue that was brought up with the courts as well. We don't think it's a functional bill.
Thank you. Senator Rome, did you have a question?
Yes, thank you, Mr. Chair. A question for the patron on this. So first, would the patron please respond to the concern from OES regarding the date number? And I guess what I'm particularly curious about is if we were to keep it, I guess, even if you add an additional week, or if it's like 20, because right now on lines 29 to 34, it repeatedly says 21 days, right? If we were to make that 28 days or 30 days, would that have a detrimental effect to the patron's intent, while still at the same time being able to address the concern that came from OES?
So I'm going to be very honest and very transparent. That part was not in the bill to begin with, but I've been very intent on the housing bills that I've worked on to make sure that I have as many of the stakeholders, Mr. Chair, that I would have as many of the stakeholders at the table as possible. We heard pushback from some of the landlords and the AOBA and VAMA, and I wanted to take that into account. And so the bill that you have before us is the compromise version that would remove the, I guess, the opposition from those entities. And so that's why, I was okay with it. It's not supposed to cause any heartburn. It's actually supposed to get to the concern that I think that another senator raised, where it's like, if we're going to keep extending, this was a good faith measure to, if we're going to extend it, at least show we're not trying to prolong this forever. We're just trying to prevent evictions.
Right. So, Mr. Chair, follow up.
Yes, Senator Rome.
Thank you, Mr. Chair. So, I guess in that case, I don't want to cause harm. I mean, I'm going to be yes. At the same time, I do want to take serious the concerns of OES in terms of is it possible to do the docket? And so if our representative from VPLC can weigh in on that, that'd be great.
Thank you, Mr. Chair. Christy Mara with the Poverty Law Center, Senator Rome. I think the thing to focus on here is that this is just the initial hearing. And so the substitute before you says that that has to be heard or scheduled within 21 or 30 days of the date of filing. But that is not a full hearing. That's an initial hearing. It's often true that at that initial hearing, a tenant who is going to contest the matter will appear and in most cases ask for a continuance. It's often true that people don't come to those initial hearings. We still have something in the neighborhood of a 30% default rate, 30 to 40% default rate. So I appreciate that it may be appear to be overwhelming for OES, that this is being pushed really back only, I think, 9 days, because I think currently they're supposed to be heard within 21 to 30 days, or something similar to that. Right. Right, it's a change from, the case is supposed to now be heard within 21 to 30 days. Under this substitute, it would be 14 to 21 days. And again, it's just the initial hearing. It is generally not the hearing at which evidence is provided.
Okay. Was there other questions from the members of the panel or comments?
Mr. Chair.
Senator McPike.
Is there a response to also the service duration question in terms of the process has to work functionally? And if the people who have to administer the process have issue, we need to fix it. Otherwise, it's unworkable for everybody involved, and that doesn't help anybody in the end.
Yeah.
If people aren't getting notice, they're not getting service, they're not getting help or relief for or against either party. And so...
And thank you, Mr. Chair, Senator McPike. This 14 days should allow for service. I mean, we normally are seeing service done within that time period. When we were meeting with the delegate and the other stakeholders about this, and I'm sorry she's not here now, but my colleague who has very recently practiced in general district courts very carefully talked about the time needed for service and felt comfortable with the 14 to 21 days.
I think we had a motion to report in a second. Is there any further discussion, or should we vote on that motion? Yes. Okay, so let's open the roll.
Ayes 8, noes 5, 2 abstentions.
Thank you, Mr. Chair.
Okay, thank you. Okay, I think that Delegate Munden King, I'm just going to expedite because I know you had another meeting, so why don't you come forward? And I believe that your bill was...
Well. Thank you so much, Mr. Chair. Just please ignore the cries of those freshmen over there.
Okay, this is...
Nothing strange here.
Okay, I think we're on House Bill 1461, is that right?
That is correct.
And this was similar to Senator Bagby's SB 544?
So, Mr. Chair, this is actually quite different from Senator Bagby's bill in that he addresses short-term rentals as well, but his address rentals where the primary owner is living in the property. My bill addressed those who are renters. And what my bill does is says that localities cannot enact ordinances that prohibit renters simply because they are renters from participating in short-term rentals. It also provides that they must have permission of the owner.
I understand there's a substitute?
And actually, we have a substitute. Thank you. I see the sign waving.
Okay.
And I can explain what that does.
Okay, well, I hear a motion and a second to adopt the substitute, so all in favor of that, please signify by saying aye. Aye. Any opposed? Okay, we now have the substitute before us, and why don't you explain that?
Thank you so much, Mr. Chair. So what the substitute does is bring in some of the concerns of localities by putting a cap on the number of short-term rentals that that renters can put on the market for short-term rental in one locality. So it limits it to if you are renting a property and you have the permission of the owner, you can put it up for a short-term rental, but you can't do it for multiple properties. And that brings the localities to a better place and also gives us some ways to also protect our housing stock.
Are there questions for Delegate Munden King?
I have a question, Mr. Chair.
Yes, Senator Rouse.
Delegate King, for example, City of Virginia Beach already adopted a short-term rental policy as well. Would this be, does it conflict with it, or are they grandfathered in with the short-term rental with this bill?
So Mr. Chair, I would say to the senator, I'm not sure on the specifics of the Virginia Beach model, but I don't believe we added a grandfather clause to this because we're specifically saying that you can deny them. You can just not say that it's only because they are renters. There would have to be, and I'm not sure that the Virginia Beach ordinance is only for renters. I think it has other, so I'm not sure that it would be impacted.
Okay, I may abstain from your bill, but that doesn't mean I don't like it.
Okay, and Delegate von Valkenburg?
Yeah, thank you, Mr. Chair. And I have a question that kind of follows on Senator Rouse's question, but maybe a little bit more specific. And I talked to counsel about it, so I think we're in a good place, but I'm going to have her state that publicly. Because the substitute does change the language too, which I think might change the answer. But in Senator Bagby's bill that we did pass and then the House passed today, so we'll be going to the governor, there's language that says, that kind of grandfathers in the localities like Virginia Beach, like Henrico, that have a policy already. And the fear was that this bill would gut that by essentially the second bill would come in and gut that provision. And so I asked counsel if that was true. And so I just want counsel to put into the public record what they think the answer to that is.
Counsel, can you address that?
Thank you, Mr. Chair. Senator Van Valkenburg, I do not believe they're in conflict, and they don't gut each other.
Which, Mr. Chair?
Yes, Senator Van Valkenburg.
Which would mean to kind of come back around to Senator Rouse's question that localities that already had a grandfathered in policy should be good.
Are there those here in support of HB 1461 today? In the room, please come forward.
Mr. Chairman, Ron Jordan, representing Airbnb. And we support the bill. We've worked with the other stakeholders and under the delegate's direction, and we think we pretty much have peace in the valley on this. And Senator Rouse, if I could respond to your question, I spoke with the Virginia Beach lobbyist outside before the break, and he indicated to me, you could please verify that the beach didn't have any problem with it.
Was there any others come forward?
Thank you, Mr. Chair. Erin Corman with the Realtors. We also support the bill.
Okay.
Mr. Chair, members of the committee, Bisma Ahmed with the Apartment and Office Building Association, Virginia Apartment Management Association. We also support.
Thank you. Okay. If there are any other, yes, Senator Rum.
Thank you, Mr. Chair. A question for the patron.
Yeah, please proceed.
Thank you, Mr. Chair. Just because the patron and I both represent Prince William, I was wondering if the county, how this basically affects current county policy, if there is one. I'm honestly not familiar with that section of county ordinance and whether the county's actually weighed in on it.
Thank you, Mr. Chair. I would say to the senator that I have not heard from our county, which would give me great hope that they do not have an issue with the bill, or they would have highlighted that for me. But thank you for always looking out for the home interest. You know, I appreciate that.
Okay, so the bill is before us. Are there anyone else in the audience who has a contrary view who wanted to be heard? Okay. There's a motion to report and a second. Okay. So unless there are further comments, we'll proceed to vote.
Ayes 11, noes 4.
Okay, the bill reports. Thank you.
Thank you, Mr. Chair.
Okay, next we have Delegate Glass. I believe that's HB 322. Is that right, or do you have more than one bill?
That is correct. House Bill 322. Mr. Chair, so House Bill 322 creates a multi-state license for cosmetology, so to allow for uninterrupted practice of cosmetology between member states and support specifically, this came from the directive to make Virginia a better place for military spouses. So the relocation of military members and their spouses by enabling continuance of practice. Getting this bill through would have put us at the forefront at the table with the 7 convening states.
Other states have already adopted this compact?
I can tell you right now. Okay, I don't have my map on me of who's already adopted the cosmetology compact. I want to say that there's already 3, but I don't want to misspeak.
Mr. Chairman.
Senator Reeves.
Doug Glass, would this help military spouses that would have, let's say, cosmetology license in North Carolina coming from Camp Lejeune or somewhere up there, and that would help them in the transition?
Apologize. Mr. Chair, I would say if North Carolina is one of the either states that have enacted or have current legislation to become a part of the convening compact, then this would help military spouses that are coming from North Carolina be able to go cross state lines to do cosmetology.
Okay, Senator Aird, did you have a question or comment?
Question for the patron, Mr. Chair. I just wanted to make sure with the structure of any of these compacts, we would not compromise the standards, like the numbers of hours going towards like their licensure in structuring this, correct?
I would say, Mr. Chair, I would say to the senator is no. There are 2 separate licensure processes. There will still be the standard Virginia licensing process. And if once these member states convene and decide what that multi-state compact looks like, if someone wanted to apply for the multi-state license, then they would have to go through that other process without compromising what Virginia already has in place.
Thank you.
Thank you. Okay. Was there... Okay, I understand 3 states have adopted it, and it's pending in 10 others. Are there those in the audience waiting to speak in opposition to HB 322 or to speak for it? And I assume there's no one online on this particular bill? Okay. Great. There's a motion to report and a second. All in favor, please indicate on the electronic voting board. Others do the same as well.
Ayes 15, no 0.
Gratitude, Mr. Chair.
Thank you. Okay, next we've got Delegate Delaney. And on deck will be Delegate Campbell.
Good evening, Mr. Chair. Good evening, committee. I have HB 1370. And I do have a substitute.
Okay.
Amendments. I have amendments.
Move the amendments.
Okay, this is amendments to HB 1370. All in favor of adopting the amendments signify by saying aye.
Aye.
Any opposed? Okay, why don't you explain the bill as highlight the amendments if you would.
Thank you, Mr. Chair. So the amendment clarifies the definition of medical debt to exclude debt charged to a typical credit card, but to include debt charged to credit cards specifically for the sole purposes of healthcare services. There are certain credit cards that may be marketed at certain healthcare facilities, but they are also primarily used for beauty services and other kinds of semi-related to medical care. And we want to make sure this amendment relieves some of the concern that existed around this bill and has got us to quite a neutral place. Which I think will serve to help most people in the Commonwealth. The bill before you prohibits medical debt from being reported to consumer reporting agencies by medical care facilities and collection agencies. It does not prohibit the bill from being collected. One's credit score should be used by a lender to determine the risk of an individual to be given credit. Having been sick and having debt because of that illness should not influence someone's ability to get a car loan at a certain rate, to rent an apartment, or to qualify for a mortgage. It's not correlating to the purpose of a credit score. A credit score shouldn't be used as leverage. It's an indicator of risk. There are other ways that debt can be retrieved. There can be a court order. There can be garnishing of wages. If someone owes debt, there are plenty of remedies for the facility that's owed to collect that debt, reporting to a credit agency and affecting that person's ability to live the rest of their life because they were ill should not be a reason.
Ayes 13, no zero, 2 abstentions.
Thank you, Mr. Chair, and thank you, committee.
Now, in the queue, I've got Delegate Campbell and McClure, Paulson, and Lethbridge.
Thank you, Mr. Chair. House Bill 1309 is really just a bill that will allow the State Emergency Medical Services Advisory Board and the Board of Veterinary Medicine to develop guidance around the treatment and transport of fire, police, and search and rescue animals. It's really pretty simple. That's what it is.
May I ask where the bill came from? Is this based on an incident that occurred?
Yes, Mr. Chairman. So there have been some incidents that have happened where these animals were on the scene of an accident, and their handler would typically be the person that would transport the dog or provide the care. But in a situation where the handler's hurt or caring for someone else, there was confusion as to what could be done to transport the animal.
This requires guidelines. It doesn't require that the result of the study be a certain, does it prescribe the results of the study, or it just requires guidelines to be established?
Yes, Mr. Chairman, just require some guidelines so that when those situations do arise, when you have a canine that's being injured in the line of duty, that the people know exactly what they can do and what they cannot do.
Okay. Are there any questions for Delegate Campbell?
Move to report.
Okay, there's a motion and a second to report. Is there anyone in the audience waiting to speak on this particular bill? Okay. We will, unless there's further discussion, we'll proceed to vote.
Ayes 13, noes 2.
Thank you, Mr. Chair.
Thank you. Okay, Delegate McClure.
Yes, Mr. Chairman. Mr. Chairman, members of the committee, HB 405 is before you. And it directs the Commission of Electric Utility Regulation to evaluate the electrical distribution infrastructure required to support electric vehicle charging stations in new single-family homes and multifamily developments. Based on current trends, Virginia's residents will increasingly be reliant on electric vehicles in the near future, and this bill will allow us to plan for safe deployment of EV charging stations as we move forward. And so this bill stems from discussions between the home builders and the environmental community. So there's peace in the valley about how to remove those barriers and lower the cost of building EV-ready and EV-capable residential communities. Mr. Chairman, members of the committee, I hope you will vote in support of HB 405, and we have some folks here from the environmental community and Andrew Clark from the home builders.
Okay, there's a motion and a second to report this bill, but we're going to hear if there's anyone waiting to speak first in opposition to HB 405. Anyone want to weigh in? Okay, is there anyone here who would like to just briefly weigh in support? Thank you. Okay, thank you for being brief. Okay, there's a motion and a second, so unless there's further discussion, we'll proceed to vote.
Ayes 9, no 6.
Thank you, Madam Chair. Mr. Chair, members of the committee.
Thank you. Okay, next we've got Delegate Carlson, followed by Delegate Lethbridge, and then Delegate Carr. Welcome, Delegate.
Hello, Chair and members of the committee. House Bill 1272 strengthens the Virginia Residential Landlord and Tenant Act in regards to providing copies of the lease. Specifically, it makes it so that you have to provide a signed copy of the lease within 10 days rather than just a copy within 30 days. Signed copy is important because you need the executed contract if you do have issues that you want to raise in court. And it also provides that the landlord has to provide a copy of lease without pay. They can do that electronically, though,
Mr.
if
Chair?
they'd like.
Okay. Are there questions from members of the committee?
Mr. Chair.
Senator Aird,
For clarification, question for the patron, Mr. Chair.
please go ahead.
If a tenant is going month to month, how does this affect them if they're required? Am I understanding that you're requiring them to sign the lease? And how does that affect them if they're going month to month?
Chair, I would respond, and I might not be understanding the question correctly, but I believe if there is no signed lease, they would not have to provide it. But currently, they're required to provide the lease within 30 days of signing it, and I'm saying they have to provide that signed copy within 10 days, so I'm not sure it would change. But I might not be understanding correctly, and I have people here to answer questions if there's more technical questions. I don't think it would affect that, would be my answer, Chair.
So, Mr. Chair, just to make sure, this doesn't change an individual who is not seeking to be under a leasing agreement.
I would say to the delegate, or to the senator, I'm so sorry, the senator chair, that is my understanding.
PBI.
Okay.
Second.
Okay. Now, are there further questions, or I understand, is there anyone here in opposition to HB 1272? Anyone who wanted to weigh in support briefly? Come forward. Okay. Okay, we're seeing thumbs.
Thumbs are good.
Okay.
Reposable.
There's a motion and a second to report HB 1272. Please indicate your preference on the electronic voting board.
Ayes 15, no zero.
Okay, thank you.
Chair.
Okay, next we've got Delegate Leftwich, who will be followed by Delegates Carr, Keyes, Gamara, Askew, and Bloxham.
Thank you, Mr. Chair, members of the committee. House Bill 1482 actually came to me by way of a constituent who said, does Virginia have a process to remove someone who is essentially a trespasser on your property? And I said, well, we have trespass laws, we have other ways of dealing with this. And then I began to see these articles around the country where someone goes on vacation, they have vacant property, someone moves in, and then they call the police come, and whoever's in the house says, well, I have a lease. And then the police say, well, this is a civil matter. You need to go through the courts, file unlawful detainer and everything. So this is not an attempt to roll back or undo any of the landlord or the tenant protections that the General Assembly has enacted recently. It's simply a mechanism so that if someone is essentially squatting on property and you file an unlawful detainer and the owner swears there's not a lease and there's never been a lease, then this person is entitled to an expedited hearing. And then the court would determine whether or not there is some type of relationship that would kick them into the landlord-tenant laws or whether they truly are a trespasser.
Mr. Chair.
That's it in a nutshell.
Senator McPike.
So would this cover the condition where I've rented my house to Senator Reeves, and now he's sent it out to Airbnb for then a sublease for that too?
No, because this bill says that no lease or there is no lease and no lease ever existed. So it's purely a situation of trespass.
Are there other questions from members of the committee? Yes, Senator von Valkenburg.
If you look at line 31, 30, 32, it does say if no rental agreement exists or has ever existed between the owner and the occupant. So the occupant, to Senator McPike's question, the occupant might not be the person who did the agreement. So do we need to make a language tweak there?
Well, I will defer to your counsel on this, but that would be a sublessee situation, and the master lease would probably govern that from my perspective. But I'll defer to your counsel, and if you want to make that amendment, I would view it as a friendly amendment.
Okay, maybe we can ask counsel, do we need to add sublessee into that, or is it the existing language cover that situation?
So, Mr. Chair, within Title 55.1, occupant is defined, it's in Section 55.1-2900. Occupant means a person, his sublessee, successor, or assign, entitled to the use of a leased space.
Senator Rouse.
And maybe this question is for council. If someone has a home and they rent their room out to a friend who lives in the house, and then that person, the homeowner, decides because they're going to sell that home now, but the friend has nowhere to go and they never signed the lease, but they've been paying rent, how does this affect them?
So
because my understanding is that if someone's living in your house and there's been an exchange of money to stay in your house, that is a lease. Is that
you can have a verbal lease as well as you can have a written lease. And I mean, my intent would be that this bill would not prevent that person from staying, or at least arguing they have a right to stay. Purely in that situation, they had original consent to be there, some way, shape, or form. My bill is only intended to deal with trespassers, people who had absolutely no right in any shape or form at any time to be there.
Thank you. There's a motion and a second to report HB 1482. I don't know that we took any testimony. Is there anyone waiting to speak against this bill? Okay. Anyone want to indicate support? Okay. There's a motion and a second, so we'll proceed to vote.
Thank the committee.
Thank you.
15 no 0.
Okay, and in the queue, can someone see the queue in front of me? Is Delegate Krizak signed up on there as well? Okay, good. So we've got Delegate Carr, Keyes Gamora, Van Askew, Bloxham, and Thomas. Delegate Carr, welcome.
Thank you,
Okay,
Mr. Chairman.
let's give our attention to Delegate Carr.
We look at HB 1116 first.
Okay, that was 1116.
Yes, sir.
This is the procurement bill. I guess you have not yet worked out the language to be parallel.
This is not that.
Oh, this is another bill,
not the one
another
that,
procurement bill.
Central Lock and I are
Okay, and if
working
this
on.
bill is, okay,
This is a procurement bill, but it's a little bit simpler.
okay. 1116.
Yes, thank you. The purpose of this bill, which raises the limit for public bodies to use purchase procedures for construction contracts from $200,000 to $300,000, is to make life easier for procurement officers across the state when doing small construction projects, mostly repair and renovation. Since 2020, when it was last raised, procurement officers across the state have seen construction prices on small repair and renovation projects go up significantly. This bill would address these increases. A small purchase procedure allows public bodies to use a much simpler process to get quotes from contractors on smaller projects rather than having to use a formal invitation to bid process. This will allow small projects to be done quicker and with much less administrative effort.
Move to report.
Okay, there's a motion and a second to report. Is there anyone waiting to speak against HB 1116?
Those online who would like to speak in opposition, please raise your hand electronically. There are no speakers, Mr. Chair.
There's what?
No speakers.
Oh, no speakers. Okay, so unless there are further questions, we can go ahead and vote.
Ayes 15 no 0.
The next two have to go to finance.
Okay, and now you have.
Thank you, Mr. Chairman, members
Sure.
of the committee. And then I have 1105. Perhaps we do that one
Okay,
next.
this is a zoning for housing production
That's
pilot
correct.
program. If successful, the motion would be to report and refer to Senate Finance. So we'll direct our attention to 1105.
1105 establishes a pilot program sourced from a JLARC recommendation from their 2021 study on the state's affordable housing needs. It creates an incentive grant program administered by the Department of Housing and Community Development for localities who opt into affordable housing zoning practices currently available to them. Grants can be used for expenditures, including the production of affordable housing, but also including school construction, public safety facilities, libraries, parks, stormwater, or water and sewer lines, among other public good projects. This bill would initiate a pilot program for the City of Richmond, City of Manassas Park, Chesterfield County, Hanover County, Henrico County, Prince William County, Spotsylvania County, and Stafford County. The bill was unanimous in general laws and passed the House by a vote of 86 to 13.
Okay, are there questions for Delegate Carr? Are there those who would like to speak in opposition to HB 1105? Are there those waiting to speak in support?
Those online who would like to speak to the bill, please raise your hand electronically.
Please come forward.
Okay, great. Good evening, Mr. Chair, members of the committee. Isabel McLean with the Virginia Housing Alliance, and we strongly support the bill and are grateful for the patron for bringing it. Thank you.
Thank you. Okay, are there questions or motions? Senator Rum.
Thank you, Mr. Chair. Mr. Chair, question for the patron. So, Mr. Chair, because the patron mentioned all three of my localities in her speech, I would just like to basically just ask about two things. So, number one is we had a bill about ADUs that came over from this body that recently died in the House, where there was a lot of consternation over it, but obviously it did get out. I just want to see, number one, what sort of local ordinances are already on the books right now in any of the localities that were mentioned with this that the pilot program would otherwise change or otherwise, I don't want to say interfere with, but would basically otherwise usurp?
Mr. Chairman, Senator, there aren't any that would change. It just it's what's already existing in the zoning of the various localities.
Okay, so then, Mr. Chair, follow-up question.
Yes, Senator Rum.
Thank you, Mr. Chair. So, Mr. Chair, it would be correct to assume that this case, that between, especially where I represent Manassas Park, and Prince William, that they're more or less under this granted the green light to just kind of continue what they are currently doing, and that this isn't going to make a substantial change to how they're doing business right now?
That, Mr. Chairman, that's correct, Senator. It would be just make it more available for them.
Thank you, Mr. Chairman.
Move to report and refer to finance.
Second. I hear a motion and a second to report and refer to finance. We'll proceed to vote unless there are further questions.
Sue Walsh.
Ayes 15, no zero.
Yes.
Okay.
Mr. Chairman.
Which bill number is that?
This last one is 1108. And this is one that is very, very similar to, that I would like to move a substitute, please.
Okay, so we have a substitute for House Bill 1108. Is there a motion to adopt that substitute?
Second.
Okay, so all in favor of adopting the substitute signify by saying aye. Aye. And any opposed? Okay, so we have a substitute. This is similar to Senator Locke's bill?
Yes, it is.
So now, have you all conferred, or is this different than her bill that passed out of here?
Yeah, if I may, yesterday, Senator Locke's bill was in general laws, and this same substitute was put on it. We've been working, and there are 4 words that are different in Senator Locke's bill and my bill, and so that would indicate that would be in that substitute.
Okay, so so those 4 words, I guess, need to go to conference.
That's right.
So I would entertain a motion to overlay. Okay, so there's a motion second to overlay Senator Locke's bill on top of House Bill 1108, so it can go to conference. All in favor, say aye. Aye. Okay. Any opposed?
Move to report and refer to finance.
Okay. So motion and a second to report and refer to finance. This can get worked out. Please signify your preference on the voting board. Okay.
Just hit it once.
Need a light touch there.
Ayes 15, no zero.
Right. Okay. Thank you.
Thank you, Mr.
Delegate
Chairman,
Carr.
members of the committee.
Okay, Delegate Keys-Gamarra. Welcome. This is HB 1475 to adjust the heating and cooling season.
Yes. Thank you, Mr. Chair, members of the committee. HB 1475 is in response to a number of my constituents who live in those high-rise apartments and have not been able to adjust the temperatures. Under Virginia's Property Maintenance Code, Group R-2, apartment builders owners.
Sorry, Mr. Chair, can we get the conversations in the back out of the room?
Yes, too. Just let's give our complete attention to the patron. Thank you.
Building owners must maintain air conditioning to keep indoor temperatures no higher than 77 degrees from May 15th through October 1st. Additionally, building owners are required to provide heating that maintains temperatures that are above 68 degrees Fahrenheit from October 1st to May 1st. Virginia has trended towards unseasonably warmer spring temperatures earlier in the season, but a number of landlords have not adapted to those changes, opting to run the heat during 90-degree days. Since the legislature has historically deferred the state regulatory board on building code matters, this bill simply instructs the Board of Housing and Community Development to reevaluate the property maintenance code and require property owners to provide air conditioning in April rather than May. This was last done in 2019, and this proposal will be vetted through the board's usual regulatory process. So I would ask that you report this bill for passage.
Thank you. And this is Section 1 bill that requires evaluation rather than requires a conclusion to their deliberations, right?
Yes.
Okay. Are there any questions for Delegate Keys-Gamarra? Are there any, before we take motions, is there anyone here to speak against this bill?
Mr. Chairman, we have a speaker online.
Okay. If you could unmute yourself and show yourself on camera and provide your testimony.
I'm moving them into the room right now. Sheila Casey, you can unmute, turn on your camera, and provide your testimony.
Mute. Okay. I wasn't that familiar with your layout here. Can you hear me?
We can't see.
Barely, if you could, we'll turn up our volume. If you could show yourself on camera, please. Okay, welcome. We saw you for a minute.
Okay. Is it on now?
Yes, we can see you and hear you if you could speak up.
Great, sorry. It's important to realize that this law does not impose any new obligations on landlords. It only changes a date of an existing obligation that they have to provide air conditioning in the summer. Currently, the way the law is written, they have to provide heat until May 1st. And many buildings, especially older buildings like the one that I've been in for 20 years, cannot supply both heat and air conditioning simultaneously. So if they're providing heat, there is no air conditioning. The law is currently requiring them to provide heat, or this is how they've explained it to me, that the law is currently requiring them to provide heat until May 1st, and then they have up until May 15th to turn on the air conditioning. What this means is that we often are just really sweltering during the month of April, and it doesn't seem reasonable to have heat during April when really we need the air conditioning much more. So Delegate Keys-Gamarra is proposing that that date be changed to April 1st when the air conditioning gets turned on. And I believe it would make life much better for many of us. I know that many of my, several of my neighbors have moved out for this very reason, because it is an old building. We have many wonderful things here that make it a nice place to live, but having it be sometimes even into the 90s in your apartment makes it very difficult to work, since many people now work from home, and very difficult to sleep.
Okay, I think we understand your support. If you could just wrap up, we're going to bring this to conclusion shortly.
What I want to say is I know that sometimes there's some cold days during April. April, but I believe that the cold is much easier to deal with. For one, space heaters are only about $20. Air conditioners are expensive. And I just believe that we would be much better off having the air conditioning in April rather than the heat. Thank you very much.
Thank you for your testimony. Okay, we've got two committee members who had a question or comment. Senator Van Valkenburg first, and then Senator Aird.
I don't know who this is a question for, but you learn something new every day here. We mandate by code the exact temperature in these buildings. That's crazy.
This bill would require that that there be a review.
We don't, but I guess, Mr. Chair, we don't provide flexibility within that code for what happens. I mean, I'm going to vote for the bill, but maybe this is homework for me in the summer.
Before we turn to Senator Aird, I think we might have an expert up front on that. But some older buildings, you have to either have heat or air conditioning. But do you want to clarify that?
Mr. Chairman, Andrew Clark with the Home Builder Association. It just sets a basic range of when you've got to provide cooling and when you've got to start providing heat. It doesn't say specific temperature. It just says, hey, basic quality of life, standard of living during this season, your system has to be able to hit this certain temperature. And so it was adjusted a year and a half ago, a couple of years ago, 2019, as an emergency regulation, because I think it went up as high as 90 degrees. Which was just kind of absurd, but that is in the building code. It's a pretty simple fix, and this bill just gets that moving.
Okay, Senator Aird, did you have a comment or question?
Thank you, Mr. Chair. I have two questions because I'm totally baffled by this. I guess my first question is, do I understand that these individuals in these units basically can't control their own temperature depending on what time of year it is? Is that what you're saying?
Right. There's a time period for air conditioning and there's a time period for heat.
So if I'm further question.
Yes, please continue.
So if I am a senior, maybe not a senior, if I'm an older woman going through menopause in the winter, I mean, and I want to turn my heat on in the winter, are you basically saying I cannot do that?
Mr. Chair, I'm not sure. I may be misunderstanding the question, so I may phone a friend again.
I'll repeat the question, Mr. Chair. My question is, if I am a woman going through menopause in the summer and I want to turn my AC, and I want to turn, or maybe in reverse. In reverse. I want to be, yeah, exactly. I want to have the freedom to adjust the temperature. Are you saying that depending on the time of year it is, I can only control the temperature for that season?
That, Mr. Chair, I would say to the senator, that is the existing regulation for those.
This occurs in mostly in older buildings where there's a binary choice of whether to have the heating system on or the air conditioning system on for all the units.
It's extremely costly to change
And you can adjust it within your unit, but only with what's offered.
It's an internal adjustment. It's just the building.
So what the delegate is proposing is that the Board of Housing and Community Development review revisions to the maintenance code to keep up with the weather patterns that have been more frequent currently.
Move to report.
Second.
Okay, there's a motion, a second. Are there any, unless there's further discussions, we can proceed to vote.
I'm against menopause.
Ayes 9, no 6.
Okay.
Thank you. Have a
Thank
good
you.
evening.
Okay, next we've got Delegate Askew, then we've got Bloxham, Thomas, and Krisak. Okay. Okay, we'll take it last then. Okay. Thank you.
Good evening, Mr.
Welcome.
Members of the committee. Thanks so much. Before you today, I have House Bill 1452, which makes a small set code sections in this small changes code section, and the bill requires the state agencies to establish and maintain a comprehensive diversity, equity, and inclusion strategic plan yearly in coordination with the governor's diversity, equity, and inclusion director. The biggest change in this bill, Mr. Chairman, is that the legislation requires each state agency to submit an annual report to the governor and the General Assembly as well as having it to us and the governor by July 1st of each year.
Second.
There's some, the report is on the DEI program, their diversity, equity, and inclusion goals in coordination with the governor's director each year. Okay, there's a motion and a second to report this bill. Is there anyone waiting to speak against this particular bill? Okay, well, we can proceed to vote then.
Ayes 15, no
It's like in
zero.
basketball, you can always. That's right. Got it right. Okay, thank you.
Thank you, Mr. Chair. Members of the
Bill
committee.
reports. Okay, now we've got Delegate Block. Let's go to Delegate, I think Bloxham's not here, so we'll go to Thomas and then Krizak. We'll do that last. Okay, welcome back. You're here for HB 338, which was a data center bill about site assessments.
That's correct, Mr. Chairman. Kind of already presented it last time, so happy to do that again if you'd like, or continue to take questions if something's developed in the last week.
Well, let's just remind the committee, this bill is a little bit different than Senator Rome's in that it provides that a locality may perform a site assessment before approval, but does not require that. Is that right?
That's correct, Mr. Chairman. It is permissive.
Okay. So we can either choose to report this bill, which is a little bit different than Senator Rome's bill, as is, or we could send it to JLARC as we sent some others.
Mr. Chairman.
Senator Rome.
Move to report.
Okay, there's a motion and a second to.
Mr. Chairman, substitute motion.
The first motion was to report the bill, and the substitute motion is?
To send it to JLARC for study. Carry over and send it to JLARC.
Okay, so first we'll vote on the substitute motion, which was to send to JLARC with the letter
Mr.
for
Chairman.
study. Senator Rome, want to address that motion?
Yeah, speaking to the motion, please.
Sure.
All right, thank you, Mr. Chair. So, Mr. Chair, a few things regarding the motion. Number one, when this bill came up in the House in the first place, and they had the same opportunity to evaluate the JLARC question on this, which they did on other bills, other House bills, which are going to JLARC, they specifically carved this one out because of the permissive nature of it as opposed to the prescriptive nature of my bill. That's why they decided not to send this to JLARC, and I don't think that in this committee that we necessarily have to override that decision, even though obviously we are in conflict with the House on plenty of things all the time, and them toward us. I think on this in particular, because of the way it's drafted, because of the design of the bill, and because of the intent of what is before us right now, it is not necessary to put this into additional study, considering that my bill is being studied, and that came as the will of this committee. This bill is not in conflict with mine, and therefore I don't think it is necessary for it to go into the same place that my bill is going to.
So I think we're clear that the motion before us is to send HB 338 to carry it over with the study at JLARC. Unless there's further comments, we can proceed to vote.
That's the substitute motion.
Yeah, we're voting on the substitute motion.
Ayes 9, noes 3, 3 abstentions.
Okay, thank you for coming
Mr.
back
Chairman,
and waiting all this time. Thank you. Okay, now we've got Delegate Krizak.
This one's going to finance.
And this bill, should it be
Sure you wanna
reported,
grab me?
would be referred to finance.
You sure there's no more delegates?
We've got more bills,
Nah.
but
Thank
no
you,
more
Mr. Chairman.
delegates.
So it's great to be in front of the hardest working committee in the Senate.
Well,
I
being
know
my
what it's
landlord,
like
I know
on
you're
our
going to
side.
turn off the heat or the air conditioning if I keep you here too much later. This is the Manufactured Home Lot Rental Act.
Yeah, this is, so what the effort here is to help Virginia maintain its only unsubsidized, truly affordable type of home ownership, which is manufactured homes. This substitute, and there's a substitute here that needs to be,
Move the substitute.
Okay, there's a motion and a second to adopt the substitute for HB 1397. All in favor, please say aye.
Aye.
Okay, any opposed? Okay, the substitute's before us. If you could, just as you explain the bill, maybe point out what's differed in the substitute.
Yeah, what it does is it provides a right of first refusal for purchase of a manufactured home park to the locality where a park is located. When we started this bill, we worked with all of the stakeholders on both sides of the issue. Everybody really has the same goal, and that is to help the residents of these parks, but to be fair to the owners of the parks as well. And at this point, it's not a right of first refusal for purchase by the tenants, if you will, but by the locality working with the tenants and possibly nonprofits as it's been done in other places. So under this right, if the locality makes an offer with the same price and substantially similar terms and conditions as the offer received from the third party, the park owner must sell to the locality if the locality makes the offer within the 90 days of receiving notice that the park will be sold. And if the locality decides it doesn't want to exercise the right of first refusal, they must immediately file an affidavit with the circuit court confirming the park owner complied with the law and the sale to the third party can close without waiting the full 90 days. So it's importantly, the locality can transfer the right of first refusal to a housing nonprofit, and that nonprofit has to comply with the same deadline and affidavit requirements. So it's a very different substitute from the bill that passed the House, because we promised during the House process that we would continue to work with everybody to make it a bill that I don't think you're going to hear any opposition today from. It delinks the rights of the residents to make an offer to purchase their park from any pending offers received from third parties. I think it's more important to kind of tell you what it does not do. It does not require localities to buy manufactured home parks. It does not require park owners to sell their parks to localities for any less money or at less favorable terms than they would get from the parties. And the owners can still maximize their profits selling their park to localities or housing nonprofits, and it does not needlessly slow down the process of selling manufactured parks. And so what this does is it gives localities a better chance to prevent displacement of their residents and maintain this excellent, unsubsidized, affordable housing with manufactured homes.
Okay, we've got a few questions in the queue. First from Senator Rome.
Thank you, Mr. Chair. It's a question for the patron. Mr. Chair, I'd ask a question for the patron in this case. So Prince William County ordinance prohibits allowing new mobile home parks in the county, something which I disagree with, but it is what it is. It's been that way for a good while. I just want to make sure under this bill that if basically one of those mobile home parks were to have a transfer of ownership in whichever regard, that county ordinance isn't going to say, oh, well, there's something new here, so now we are going to be able to prohibit the continuation, for example, of this mobile home park or anything of that nature. I just want to make sure that we're protecting the mobile home parks that we currently have, and at the same time, frankly, if we could chip away at that ordinance, I would love to, but I don't know if this bill actually does that.
Yeah, I mean, the code would trump their regulations in this case. No, it wouldn't do that. And in fact, when the nonprofit or the county working with a nonprofit and the residents buy the mobile home park, it would stay a mobile home park for I think 15 years. Yes. And it could be, if the majority of the residents agree to it, they could change it into another kind of affordable housing. But it really is it's a preservation of mobile home parks.
Okay. I've got in the queue, I've got McPike, Aird, Reeves, and Rouse. Senator McPike.
Thank you, Mr. Chairman. I guess speaking to this portion of the bill with the delegate, Mr. Chairman, I think the key is you're positioning right of first refusal that does not create a lesser value to the current owner. I think the nexus that probably some of the committee members are going to struggle with is having a government interjection into contractual rights, which is not often done without eminent domain or some other faction. But I mean, I think this is a little different than the public interest is served by having and preserving the ability to have, frankly, housing that is not really mobile. No. It really is functionally stationary and is a valuable, important part of our housing stock. We faced it with East End Mobile Home Park. We faced it on Route 1. We faced it in many different components of my district, which have been significant issues to try to settle out, and it's taken years to do so. This would be, I think, is an important tool to have, but I know others might have questions about the same thing, but I do think it's an important nexus that we do recognize as we approach this.
Senator Aird.
Thank you, Mr. Chair. I'm not sure if this is a question for the delegate or council. I was just trying to make sure a earlier bill that we looked at, House Bill 1398, which was specific to localities having first right of refusal for affordable housing entities. In this bill, that does speak to first right of refusal, but specifically for manufacturing homes, that we're not adopting two different approaches to that first right of refusal. And so could you speak to whether or not we're tracking the same process? I know they're not exactly apples to apples.
Mr. Chairman, I can speak a little bit to that because that other bill was
address that. Go ahead.
Yeah, that other bill was a bill that I had worked on, and then I handed it off to my colleague, Delegate Delaney, and it's passed through the House now, and I think it's on its way to the governor. But and so that's kind of at the front end. This is at the back end, so there's no conflict at all. It's all part of it's all kind of part and parcel.
So clarifying question, Mr. Chair. I know they're two different. I know they're two different bills. I'm just saying I'm trying to make sure we're not requiring localities to take one action relative to having that first right of refusal or a notice to purchase as we are in this one. I'm just trying to, because I didn't have a chance to track through this substitute in that bill.
Thank you. Christy Mara with the Poverty Law Center. And Mr. Chairman, Senator Aird, I am not that familiar with that bill because our partners at the...
Why don't we defer to our counsel, Joanne, first, and see if she's had a chance to think about the bills in comparison.
Thank you, Mr. Chair. Senator Aird, I do not believe that they will be conflicting in any way, and they're both giving the localities the option to act, but not requiring them to.
Thank you.
Okay. I also have in the queue Senator Reeves, Senator Rouse, and Senator French. Senator Reeves, did you have a question?
I almost called you Senator. Sorry, Paul. Delegate Creasy. Do we have anywhere else in the code that we have this type of language where we set up a first right of refusal for the government to take individual property other than, we were just talking about it.
The affordable housing units.
Yeah, where we take it from the Kelo decision. Eminent domain.
This is, I don't know the answer to that question. Sorry,
Okay.
Mr. Chairman. I've never seen it, but.
Okay, and I think Senator Rouse, were you waiting as
Yes.
well? Okay.
Thank you, Mr. Chair. I think this first right of refusal is giving everybody a bit of angst. It's not that governments are going, especially localities, are going to take a property. It's just that they get a first right refusal of offer to either buy it or not buy it. It's the same thing we do oftentimes at the city council level, where we have maybe at Virginia Beach, we have a hotel or something come on back online. And from years ago, we sold them the land and said, if you ever sell this building, we get first right of refusal either to match an offer you may have or say you can sell it to the highest bidder. So there's not a requirement for localities to buy this land. It's just saying, hey, if you don't, you just need to offer us the first right. Right first. So I hope that kind of answers everybody's.
At the going rate, at the same rate the private parties offer.
At the going rate, they don't take a discount on it. You don't have to. The lower offer, it has to be at the whatever that offer is. The locality has to either match or go above it, but they can't take. It's not requiring someone to sell their property at a lower offer. So I hope that.
Does that complete your comment or question? Yes. Okay. So Senator French.
Yes, Mr. Chair and Delegate Creasy. I think this definitely looks different to me in rural Virginia than it does maybe in some urban areas. But so this passes and a municipality ends up with a trailer park or whatever, and the tenants don't pay their lease, so that then makes the town council the landlord, and we got to kick them out, and we got to deal with all that.
Mr. Chairman, no, that they would. It's the locality is kind of the agent that makes it happen, but it would be the tenants or or a nonprofit or a combination of the two would be the new owners of the park, and they would be responsible for collecting the pad fees and things like that and taking care of it. So the idea is that you're trying to preserve these. These are counties that want to save their parks, not county. We're not requiring a county to do this. So they would be going in with eyes wide open, knowing that they're going to be helping to facilitate. They would be the facilitator. They may have it for a few years or whatever, but it's a facilitation. It gives them an option. And the owner of the park doesn't have to sell it at all if he doesn't want to.
Mr. Chair,
Senator French.
could this ever work in reverse if the county wanted to get rid of the park and they were, long term, they said, let's get this and do it, and then we can do away with this because it's an eyesore or we don't like it?
No, Mr. Chairman, no.
Okay.
Mr. Chairman,
Yes, Senator Reeves.
Delegate Creasy, you show that if the county or the municipality takes over that trailer park, they have to keep it for 30 years as a trailer park? Is that correct?
I think I said it's 15 years, or the community, if the community wants to make it into another form of affordable housing, and you get a majority of the folks in the community that agree to that, then it could change in that capacity. But it would have to stay as affordable housing for at least 15 years.
Okay, thank you.
Okay, I just want to make sure that anyone who wanted to comment on this bill gets that opportunity, and I don't know if Mr. Grumbine or others had comments, but please
Those
come
online
forward.
who would like to speak to the bill, please raise your hand electronically.
Thank you, Mr.
Hello.
Chair. Randy Grumbine, representing the Virginia Manufactured and Modular Housing Association. We have worked with the delegate on this bill, and there are a few areas that we are in agreement with, that we can have some improvement. This body codified in 2020, just a few years ago, the process for the owner of the community to notify the tenants of their intention to sell the property. And that's been working. It requires a notification on DHCD's website. Also codified the payment that goes to tenants in the event that the park changes use. We recognize that both that the tenants, the cost to transfer a home today has risen due to some inflation, and we recognize that there's some work to be done in this area. The bill calls for a flat fee of $5,000. We feel like that we could do some more work in this area, and it changes by a case-by-case basis. In some cases, it may be much more. The cost to move a home is very expensive. We also see that there is robust activity in the manufactured home community space. In the last 3 years, the Department of Housing and Community Development notifications exceed 150. So there is a lot of activity in this space, and it does require some attention. The issue that we see is that a lot of these communities were established in the 60s and 70s. And so now they're reaching their age where the infrastructure needs improvements. And so some of those owners don't have the resources to do the improvements and then therefore choose to sell the property. So we have the big fundamental differences. We don't see where the right of first refusal is solving that issue. It's delaying the process of selling the community. And I would just add one last thing is that technically there's some language in there around line 120 that says that either a formal or informal request, it's in there a couple of times. We feel that that language is vague and could be widely interpreted. So we would like to see that cleaned up as well.
Okay, were there, yes, please come forward.
Mr. Chairman, members of the committee, Tyler Craddock, Legislative Strategy Group, on behalf of Manufactured Housing Communities of Virginia. Our members are in the business of operating parks. They buy parks, they sell parks, but they operate parks. Our concern with this is basically it comes down to a fundamental objection to anyone having a right of first refusal to when there's a contract purchaser involved. And again, understand our members own and operate parks, but they acquire parks. And so when you have someone who has gone in, they've done their due diligence, they've done the research, they've spent money on lawyers who ain't cheap, they go in, then to have that deal pulled out from under them, that's a little bit concerning. Now, that said, we understand that we're about preserving parks because that's what we're in the business of. And so if we want this idea of parks preserved, whether it's private ownership, whether it's nonprofits, localities, tenants groups getting into the game, we got that. There's nothing right now in the code that stops these folks from going out, engaging agents, buying a park. And we're happy to have those conversations. We give credit to the patron for his work in capacity building in the House budget to see that these groups have the resources to do it. But what I would say to you, if we want to preserve parks, there are two issues. One is supply. Senator Rome mentioned the prohibition in Prince William. I think she's exactly right. We need to have conversations about how we zone and how we do that. And the second is providing for, as Mr. Grumbine alluded to, relocation, the ability for tenants to be able to relocate, and replacement. And those are some budget issues we can talk about going forward. So with that wanted to just summarize our concerns. Obviously, we're here and happy to answer any questions and appreciate your time, Mr. Chairman and members of the committee.
Thank you for your comments. Okay. And you said there was someone online? Okay. If the people online could unmute themselves and show themselves on camera and keep your comments brief, we try to keep it to less than a minute each if we could.
Mary P., you may unmute and begin your testimony.
Hi, I'm Mary Payton. I'm the chair of the South County Task Force, which is an advocacy group on Route 1 in the Fairfax County area. And we've worked with 5 mobile home parks along Route 1 for about 5 years. And they have about 1,200 families among them. The reason we have supported this bill is because the current law is circumvented by people who come in to buy mobile home parks. They often put a penalty clause. They sign a sales contract with the owner before the tenants are even notified that the park is for sale, which I don't believe was the intent of the original Manufactured Housing Act amendments, but that's what happens. And they also put one park buyer put a very large penalty clause in that sales contract if the park was sold to someone else. The county did make an offer that was even higher than the price offered by the buyer, and the seller of the park refused it because of the large penalty clause. So we're just trying to level the playing field with this. We want the contract, any contract, to be contingent on any offer from a county or a nonprofit through the county, and we want it to be fair.
Thank you for your comments, Ms. Payton. Okay, and next.
Maria Nayla, you may unmute, turn your camera on, and begin your testimony.
Hello.
Please begin.
Hello? Can you hear me?
Yeah, we can hear you. Please begin your testimony.
Yes, my name is Marianela. I am a community organizer with Tenants and Workers United, and I have been working with a mobile home coalition in South Fairfax for over 3 years. And in the past 3 years, I have seen how communities of colors and workers' family have been displaced. And even though community members have been making huge efforts to get financial support from the local government, the community has not been taken into consideration when a parking is for sale. For example, in 2022, Harmony Place was sold to a corporation. Residents got less than 60 days notice, and the community created a tenants association. In less than 60 days, the community found a nonprofit that was willing to work with them and got the financial support from the local government. And also they offered 0.5 million more than the corporation, but they were not taken into consideration. And there are other 2 more parks that pass for the same situation. And even though the seller refused to even consider an offer from the tenants because he had a contract with a buyer. So HB 1397 will make a huge impact for mobile home residents. This bill will give a chance to keep their homes affordable and protect them for displacement. Thank you.
Thank you for your testimony. Okay.
Mr. Chairman.
Yes, Senator Reeves, I think you have a motion.
Mr. Chairman, I have a line amendment and a motion. I think it would be a friendly amendment, Delegate Creasy's bill that might give some of us on our side a little more ease if we could. And I don't have the line number, so I'm just going to go from the strikeout where it was stricken out for manufactured home parks located in Planning District 8. If we would unstrike that, I think we'd be a lot more comfortable with it.
Okay, and the result of that amendment would be to have this entire bill apply just to Planning District 8? Is that your intent?
That would be my intent, Mr. Chairman.
Okay. Well, line 18 and line 19 in particular, but in concept, the bill would apply to sale of manufactured home parks to developers in Planning District 8.
Mr. Chair, you probably have to add that language to every section, or maybe
say that one more time, Delegate.
I think you would have to add that language to every section.
Okay, yeah, throughout the bill. The
bill.
amendment in concept is to apply to Planning District 8.
Second.
Yeah. Yeah, so there's a motion to, and was there a second to that amendment?
Second.
Okay.
Mr. Chair.
Senator Rum.
Mr. Chair, speaking to the motion, and maybe someone can mention this as well, or maybe it's even a question for the patron at this point. As noted earlier, especially from Senator McPike, when he was listing some of the mobile homes where we've had this issue, and Manassas is basically like Star Central, where we had a huge issue with Eastern Mobile Home Park. I have to believe that not just Planning District 8 is having this problem, and beyond here. And so I guess I'm curious about if we make this entire bill just about Northern Virginia. Okay, that's great for our districts to whatever extent possible, especially mine, but I do have a wonder if this is something that we might be able to revisit in the 25 session to look at statewide, if you want to kind of pilot it in Northern Virginia for this, because I don't want us to just have a balkanization effect here, where just because Northern Virginia has one either reputation or stigma attached to it, depending on which side of the aisle you're on, I guess. I don't want it to just be us and not have everyone else having to play by the same rules.
Mr. Chairman.
Okay, Senator Delegate Krizak.
If I could address that, and just when we're making these changes, and first of all, I totally agree, and I'll come back with a bill next year. But the thing is, I think the notice provisions should still stay statewide. I don't think that really affects the. So if that will be reflected in the draft. So
the amendment before us, Senator Reeves, do you amend that so the notice would be statewide, but the right to first refusal would apply throughout Planning District 8? Okay, is that it? I think I hear a yes.
Yes.
Okay, so let's vote on narrowing the bill to Planning District 8 with the notice provision remaining statewide. All in favor of that amendment, please signify by saying aye.
Aye.
Any opposed?
Move to report as amended.
Okay, there's a motion and a second to report the bill as amended.
And re-refer to finance.
And re-refer to finance. Let's indicate our preference on the voting board.
Ayes 13, noes 2.
Thank you, Mr. Chair. Thank you, everybody on the committee.
Thank you. Okay.
Mr. Chair?
Yes, so
I'll go ahead
next,
and take up 878.
next we're going to take up, that was House Bill 878 from Delegate Bulova.
Yes, Mr. Chairman. So this is the bill
Let's give our attention to Senator McPike. We're almost done.
And so this is the bill that was heard in local government, which is the purchase of development rights. It was on the floor and re-referred here. And I think this is an area that needs more study. study of an idea, and I would move that we carry over and send a letter to the Housing Commission to further take a look at the purchase of development rights.
Okay, does everyone understand the motion? Okay, this was 878 to to carry over and refer with a letter to the Housing Commission for review. Okay, there's a motion and a second, and let's indicate our preference on the voting board then.
Ayes 15, no zero.
Okay, and I believe that we have one more bill from.
We do,
from
and obviously
Delegate
these people
Bloxham.
are staying here for this one because it's very important. It reduces the size of the membership for the potato board from 7 to 5.
Okay.
It's a opinion bill. He's running for re-election on potatoes.
This is a brochure bill.
Spuds
So-
McKenzie.
Okay, so this was to reduce the size of the membership of the potato board from, what was it, from
7 to 5. They currently they can't get a quorum to spend the self-imposed tax on potatoes that have been sold. Number
Okay.
of farmers is decreasing, and the size of farms are getting bigger.
It's really not a funny.
Okay, let's not get potato drunk on this.
Idaho.
Okay, is there a motion?
Move to report.
Move to report in a second. Anyone here waiting to speak on the potato board at this hour, please come forward. Okay.
Oh, you've got to be kidding.
Have you been waiting? You've been waiting all this time?
The train is moving.
Jake Tabor, Virginia Farm Bureau, we support.
Thank you for your brevity. Okay, let's indicate our preference on the voting board. He's going to speak. Okay.
Oh, someone wants to speak on the floor.
Yeah,
Speak on the floor.
Ayes 14.
Thank
no
you.
zero.
Look forward to that. Okay, that completes our docket. Thank you for your patience. The committee will rise.
Great job, Mr. Chair.
Senate of Virginia, Richmond, Virginia.